allow me to address that in my remedy section at the end. Okay. But the simple answer is, at this stage, 172 of the Constitution governs what we would suggest is how this court should deal with remedy. And that would be that under 172(1)(a), the court considering law or conduct, and this is law or conduct not just of a government entity, but of anybody. The court is enjoined, and we can give you the cases if the court wishes, is enjoined, must declare the law or conduct unconstitutional to the extent that the court finds the invalidity. And may, there's a wide discretion, under B, grant any relief that is just and equitable. So if I turn to answer His Lordship presiding directly, the relief sought in 1, 2, and 3 are all declarations. And we would suggest that those declarations of invalidity, and one sees the wording is clear, declaring the first respondent's policy inconsistent with the Constitution and invalid. And that mirrors the words of 172(1)(a). So we would submit, even if there is an alternative remedy about such as setting aside a particular appointment, our client would nevertheless be entitled to these three declarations. But I will turn to that if necessary. I've answered the question shortly, but.
Excuse me. Okay, thank you, Mr. Katz. Turning on the recommendation that you have read to us on paragraph 657, the recommendation of the Commission. I just want clarity there. Yeah. Did the Commission say the policy is unconstitutional, or did the Commission say taking into account the recommendation of the committee is the one that is problematic? Did it rule on the policy itself, or did it rule on the executive authority considering the recommendation?
Our understanding of the Commission's finding, as opposed to recommendation, finding, because as we understand it, the Commission made certain findings, and pursuant to those findings, it made certain recommendations. And what 657 is a finding. It's not a recommendation. The recommendation comes later. But the issue is the finding in our submission is that the ANC's cadre deployment policy is unconstitutional and unlawful.
So it made a finding in your weight on the constitutionality of the policy.
That's right. That's how we understand 657, read in context of the entire report on cadre deployment. And then it went on to make certain recommendations, which our learned friends say, well, that means our matter's not right. We have an answer to that. But the finding, the core finding of the Commission was 657. And thereafter it goes into, well, now that we've made this finding, what do we do about it? And that's a Commission's, let's call it business. This court's business is different. This court's business is squared within the realm of 172(1) of the Constitution. That's how we would analyze the difference between, one of the differences between what the Commission did and what this court is required to do.
Okay, because this question is intertwined to what the presiding judge has just asked. Is the problem the policy, or is the problem the executive authority taking into account the recommendation of the committee?
Understand. Well, let me flip the answer in this way. If the executive authority is not entitled to take into account a recommendation, not and these are the words, not entitled or have the right to take into account recommendations, then what possible purpose can a recommendation be? What possible purpose could a deployment policy that at its root is recommendatory, how could it have any life? Because as soon as it has life, the life is squashed because it's unlawful, because who we're recommending to may not have regard to it. So it's the same coin. It's one coin, two sides of the same coin. If the decision maker cannot take into account a recommendation, then on what possible basis is the ANC doing here? On what possible basis is the government doing here by saying our policy is good and we will continue to recommend, knowing that when they recommend, it would be unlawful for the decision maker to have regard to. So I hope that answers. But let me go further than that. As a matter of logic, were they to recommend, and the problem isn't with them, but the problem is with the decision maker, merely by making the recommendation, it's going to influence. That's a problem. If one sees it not in the way that we submit, that's two sides of the same coin. So if a decision maker cannot have regard to recommendation, on what possible basis is the party who is making the recommendation defending their recommendatory policy? Why are they here? They know it can't have an effect. So that's a problem that we would submit is more serious than it's a serious problem. I'll leave it at that. I hope Justice Mojapelo.
Now you may proceed. You may proceed.
I want to turn to the points in limine. And they are numerous. But they are captured. And that's not the word. That's not the say capture, but they are captured by the key point in limine being jurisdiction and standing. There are others, joinder, non-joinder, rightness, hearsay, etc. But so ultimately, it's about jurisdiction and standing. Let me start off by referring to, let me start off with rightness. They say, as we understand it, and I say they, I don't mean to implicate all three of the opposing respondents, and I use the word they for all ANC government and President and the Minister. But the suggestion is by one or all of the respondents that the matter is not right because the President has indicated that because of the Zondo Commission finding and recommendations, they are busy to amend, rectify, or they're going to be doing something with the policy to make or to try to assist in ensuring that it satisfies whatever it needs to satisfy. And in our, I don't know whether the court has the two bundles of authority that should have been delivered. I understand that they were delivered.
I don't have those bundle of authorities, but you can refer us to the relevant cases in the bundles.
The two case bundles. Do you have?
I don't have them.
They look like this.
No, but my colleagues say they've got them.
Well, they're very short ones. I'm not going to go into the detail of them. But in a case called Mazibuko NO versus Sisulu NNO,
You've also referred to it in your heads.
we've referred to it in my head. There's one extra case I'm going to refer to that's not in my head, which makes the same point.
Yes.
At paragraph 70, the court, Mosineki, DCJ, indicates that the speaker in that case that invites the court not to consider the validity of the rules dealing with motions of no conference because, so it was argued by the speaker, the Parliament's committee were busy amending the rules to give effect to the difficulty that had arisen, that there were no rules dealing with motions of no conference in terms of section 102 in respect of the President. So the speaker said to the court, don't deal with it, we, Parliament, are dealing with it. And that was rejected by the majority in the case because of the argument that I made to your Lordship presiding earlier, 172(1)A. And what the Deputy Chief Justice said was that he says, I'm unable to agree with the contention of the Speaker that because the parties are in the process of remedying the alleged lacuna, the direct application should be dismissed. First, the differences are between the parties make it most improbable that the lacuna will be corrected. And then the important point for our purposes, Second, once we have found, as we have, that the rules regarding the business of the program committee are unconstitutional, we must so declare. An order of constitutional invalidity, and this is the important point in respect to your Lordship's question about alternative remedies. We must so declare. An order of constitutional invalidity is not discretionary. Once the court has concluded that any law or conduct is inconsistent with the Constitution, it must declare to be invalid. And then in footnote 45, there's a reference to 172(1)(a). We would add one case that's not in our bundle, and it's called Goiking, G-E-U-K-I-N-G versus President of the Republic of South Africa, 2003, Volume 3, Essay 346, where Goldstone J, para 32 to para 33, rejected or the finding by the High Court that a challenge to a section of the Extradition Act was not right because it hadn't yet been executed. And Goldstone J said, well, the Bill of Rights talks not only about a violation of rights, but also threatened rights. And in that case, there was clearly the threat that Mr. Goiking's rights could be violated by the use of a particular, it was a certificate in terms of Section 10 sub 2 of the Extradition Act. But the proposition that I'm dealing with now is that the Mazibuko line and the Goiking line suggest quite strongly, read with Section 172(1)(a), read with the type of relief that my client sees, that clearly this case is right. The next point that they make is, in a sense, covers everything, and that is that because it's a political party, the ANC, the soundness of their policy is not to be scrutinized by the court. In other words, as we would understand the debate, for the ANC, and in their understanding, other political parties as well, or other groups as well, there is what could be regarded as a constitution-free zone. There's a zone which the ANC sits outside, and this court's got no jurisdiction to go into that zone. Because if the court could go into that zone, of course then the jurisdiction point has no meaning. And to reject the so-called constitution-free zone argument by the ANC, we have reference to the Constitutional Court in De Lange versus Methodist Church. It's in our heads. Methodist Church, I think it's Methodist Church of South Africa. Methodist Church, I think it's of South Africa. But in our bundle, it's on page 14, the quote, when paragraph 73 to 76, Van der Westhuizen in the concurring judgment makes a finding, we submit, that there are no constitution-free zones in South Africa under the constitutional regime. It was there the argument by the Methodist Church was, and it was to do with, I think, the ordaining of a woman priest who was in a relationship with another woman, and the Methodist Church said, we a church, you can't come scrutinizing our church world because of the Constitution. It's our freedom of religion, our freedom of association. It's constitution free in that sense, equality, discrimination. ANC say the same thing today on their jurisdiction. They say you've got no jurisdiction. We submit that what Van der Westhuizen said in 76. So can one say that the Constitution does not reach our private religions and social spheres? I'm not persuaded that we can. Is it not rather the Constitution, as a set of values and protected fundamental rights, indeed reaches even into the most intimate spheres, but carries with it all the rights and values it recognizes? This would include not only equality and non-discrimination, which is of high importance, but also privacy, freedom of association, autonomy of choice. All of these were violated in our undemocratic past. And he comes to a conclusion, effectively, there is no constitution-free zone. You have jurisdiction with respect, my lords, my ladies.
Mr. Katz, could I ask you to assist us with the pages on case lines when you make references?
I do apologize. I do apologize. Yes. The only time I haven't done that is in respect of the bundle, but I'm going to leave the bundle of authorities at the last time I'll mention the bundle of authorities.
No, it's fine. We've got the bundles electronically.
Yes.
We just don't know where
Yes,
you-
but if I don't know if you have them electronically, according to the same pagination that I have. So that paragraph 76 of Justice van der Westhuizen's judgment is on paginated page 14. Not case lines pagination as I've got it here twice. I don't know if you have that, but I'm not going to refer to these bundles again. I don't have a copy of just the bundles. The papers I have the case lines with.
I don't understand my colleague to be saying don't refer to them.
No.
She's saying it would be more convenient.
Yes, I understand.
Okay.
But I'm not going to go there again. So every time I touch upon anything, I'll certainly try to refer to the case lines reference. The next aspect of the points in limine is the joinder, the non-joinder. And there are various different themes to it. I understand the ANC aren't persisting with their joinder. I haven't heard from the government and the president whether they're persisting with theirs. But there are two answers. One is there is no non-joinder as a matter of law. The one is that the law is, as we understand it, is that Uniform Rule 10 capital A requires the joinder of the minister, and it's quoted in our heads, and the words are responsible for the administration of the law in the proceedings. And who is responsible for the administration of the law? Well, that is the sixth respondent, Mr. Maleka's client. That minister has been joined. There's no other need to join any other minister in terms of any other law. That's point number one. And point number two, effectively, as we understand it, all the ministers have in fact been joined by virtue of the fifth respondent being party to this case. The government of the Republic of South Africa includes the cabinet for all intents, but there's a lot of law going back many, many years as to the implication of a party being the government of the Republic of South Africa not required. Oh, sorry, the law is if the government of the Republic of South Africa is a party, then there's no need for individual ministers to be joined. I want to turn to standing.
So before you leave that point, okay, proceed with your points in limine. I just want to ask something in respect of the main argument that you made before. You can continue.
Just on standing, I wish to make one point, which is various subsidiaries to it. In the ANC's heads of argument, and this is case lines, I think it's section 12, page 10. It's paragraph, that's footnote 12. They say the following. I don't know if you have it. They say the following, the ANC says, we submit that this matter is of such importance to the country in so voluminous that the engagement of 5 counsel, I have to be just on a personal note, that's new for me, but I'll leave that to the court, and justified by these, was prudent and justified by those factors and the novelty and complexity of the case. And just a simple proposition that I wish to make is what one sees in paragraph 27 of the ANC's answering affidavit, which I've read before more than once. It is accepted by the ANC, at any rate, that, and I'll read the last sentence in paragraph 27, many decisions affecting the lives of many people have been taken by such persons. We submit that who the DA is, who it represents, its standing in its own interest, in the interest of its members and in the interest of the public interest, sorry, Section 38 of the Constitution. And bearing in mind what the ANC says is that decisions taken under this policy, which is now subject to the challenge, affect the lives of many people. How can it ever be suggested that the DA itself doesn't have standing in its own interest, in the interest of its members, and in the public interest, when it affects the lives of many people? So standing, we say, is a non-starter. There are other points in limine which I don't intend to deal with, such as hearsay, because we don't ask that the court, for purposes of this case, decide that what Ms. Barbara Hogan said under oath to the Zondo Commission is true or not. We put it there to show what was before the Commission, why members who were then members of the ANC, etc. And the court doesn't have to consider whether Ms. Barbara Hogan or Mr. Natasha or whether President was actually told the truth for purpose. That's what hearsay would be about. Told the truth for purposes of this debate. Before turning to the merits, I just want to make one point where the ANC and the President give evidence in this case which isn't entirely consistent with each other in respect of a particular issue, and that is the effect on the policy on the private sector.
Before you go there, if I forget, I just want to go back to the issue that you raised earlier on influence and recommendation. Practically speaking, some of the ministers are members of the ANC, and these policies are discussed at the meetings of the ANC, where they attend and where the president is also the chairperson thereof. Now, if you are saying the policy should be declared unconstitutional because it
suppose as a matter of principle, each one of those would be challengeable. If we write on our prior, as a matter of principle, they would be subject to a review challenge. Whether it be under Padra or the principle of legality is another debate. But one supposes that they would. But this isn't what this case is about. This case is about something different. This case is about the root of how it came about that that tree was built, that appointment was made, taking into account the political considerations of a particular body. And we here to chop that root, chop that cancer from the body politic. We're not here to chop off a branch. That the ESCOM CEO about to be appointed is an ANC cadre. We're not here to chop that down. We're here to chop down the fact that the ANC can think that it can have any influence and recommend who should be the next ESCOM CEO. That's what we're here to do. That cancer, so-called, if it is a cancer, and your lordships and ladyship will decide whether it's a cancer, needs to be removed so that there can be a clean body going forward as the Constitutional Assembly contemplated, a distinction between party and state.
So you say that alleged cancer,
Sorry, excuse me?
that alleged cancer that you're talking about amounts to a directive, an order that they should, that the state representative should do something. If I may just rephrase it.
The cancer is that there is a policy to recommend to the state what it should do when it comes to appointees.
But still the state have got the discretion.
Well, we
come to that.
Part A is that first problem with the cancer. Part B is that if the court rejects our recommending point, then on the fact there is a dictation problem.
Okay.
Which I'll turn to on the facts. And we'll see what the ANC says and what the government says about. And it's actually very interesting to see what they actually say. They say, no, we just recommend. We don't dictate. That's what they say. With the front of the mouth. But deep down in the throat, it says, you, state, if you don't do what we tell you to do, there are going to be consequences, my friend. That isn't recommending. That's dictating. And I'll explain to you what they say, not what we say, because we don't know. Secret. They do all this in secret. And I say they, advisedly, because it's fascinating and the court will have regard to why is the government defending a challenge to the validity of one particular party's policies. And the court will scratch its head and say the government should be party neutral. But here, there's a challenge, a very controversial challenge.
So you say it should be like with judges. Are you arguing that it should be like, when you apply for a position as a judge or when you're a judge, you should not be a member of any political party? That's what is the position in respect of the judiciary. So are you saying that policy should be extended to the government officials, that they should not be parties to any political organization because they are now members of the state?
Perhaps. What I do remember, when the first constitutional court was appointed by President Mandela, I remember the media talking about those members of the ANC who had been appointed to become the first bench of the Constitutional Court, immediately on that appointment resigning the membership of any political party that they may be a member of. When it comes to public officials, in a perfect world, I suppose, public servants should not be members of a political party. But we're not in, that's not what this case is about. And that's what another court on another day. Yes, there's a note that my junior's given me, and I'll read the note and I'll leave it.
No, you can consult with him.
No, he's given me a note and we've discussed this, and he says to me that I must make the point that he's not as wise as me, but he's far brighter than me. Wisdom takes aid. He says, and I'm going to read what he says, it's not appropriate for the government to use state resources, which they've done here, to defend a party, political party's policy. I'll leave it. Okay. So I turn to the policy itself, which is on page 60. So on page 60, the policy starts. I've read you paragraph 4. I do know that this was my initial booklet that was given to me on case lines had these pages divided into half, but the printing was incredibly small. For my own sake, it's still very small, the writing, but I managed to get that half page onto a full page. I don't know whether on case lines, the new case lines bundle, for me, when I accessed it last week, does have page by page as opposed to half a page. I'm just questioning. So if there is a problem with that, please let me know, and I'm instructing you to correct it. But I thought you had to correct it. I'm told by my junior it has been corrected, but my bundle goes on to on page 61. We've just emphasized 6.1. The National Conference recognized that a cadre policy can only flourish when the context of a mobilized, strong, and active organization constantly resolved to, and this is what the policy consists of, the operative part of the policy, put in place a deployment strategy which focuses on the short, medium, and long-term challenges, identifying the key centers of power. So here's a political party focusing on the key centers of political power. No, of power, sorry, not political power, of power. This just shows you, when I read it, I put in the word political because this is a political party, and there's no such political power is political power. This is power that the state has for all of us, not just a member of this party or that party. And strategy to transform these centers and the attribution of skills we require from our cadres to do so effectively. Then it says the establishment of the committees in the various NEC, PEC, etc., which is implementing, should discuss the deployment of cadres in areas of work on behalf of the movement, including the public service, parastatal structures of the movement, and the private sector. Perhaps I should just put a little flag on private sector, because what the ANC says is that they haven't succeeded in the private sector. Look, it's still white and male. And that's why that would be the case if we were in the state sector. Whereas the president says something different about the private sector point. I'll come to that. Then, on to the next page, paragraph 9. Our immediate goal, paragraph 9, is to set out in strategy and tactics is to deepen the hold of the liberation movement over the levers of the state and begin to impact positively on other centers of authority and responsibility outside the immediate realm of state institutions. And let me just stop. There may be parts of this policy which could conceivably pass constitutional muster. Conceivably. Because there hasn't been a challenge to certain, well, this challenge is about the policy as a whole. There's been no suggestion by any of the respondents that parts of this policy may be good, but other parts, were the court to come to the conclusion that there is a alleged cancer, that the good, the bad parts can be severed, cut away from the good parts. There's no suggestion of severability. So when one looks at this policy, one looks at it as a whole, and one looks at paragraph 10. The following are the key centers of authority within the state. The cabinet, and then the entire civil service. The entire civil service, down to the truck driver in water and sanitation. The CEO of ESCOM, or whatever the designation of the ESCOM group is. Premiers and provincial administration. Legislature, local government, parastatals, education institutions, independent statutory commissions, agencies, boards, and ambassadorial appointments, international organizations and institutions, non-state centers of authority, the media. The ANC want to have their cadre deployment included in who is in the media, who is in business, financial, industrial, agricultural, and medium enterprises, other social and cultural institutions like religious bodies, sports bodies, cultural bodies, etc. Guidelines for deployment. And we ask that the court have regard to this I'm not going to read it. I do want to read paragraph 47 on page 71. And this really does raise one's eyebrows with respect. It says, deployment within each of the 5 pillars requires its own act of strategic discussion. For example, within the state sector, what principles should inform the deployment of cadres in institutions with judicial or investigative functions? So the ANC accept that they would use deployment, judicial and investigative bodies. And we submit to say it is to know it's offensive to the constitutionality. The ANC want to control, leave aside the media, leave aside business. They want to control, deploy judicial and investigative functions. Investigation could be Hawks, Scorpion, police, NPA, the judiciary, judicial functions. With respect, it includes the 3 that I'm appearing before, includes the Constitutional Court, the Supreme Court of Appeal. All levers of state power, including the judiciary, including the police, including the Hawks, it would seem, fall under this policy. And your lordships and ladyship will have to decide, is that okay? And I use the word okay in loose language to mean, does that pass constitutional statutory muster? And we submit the answer is obvious. It must be enough. One goes down to 48. One sees the words to occupy. In other words, this is what the ANC said, it may make perfect sense for a particular cadre to occupy a strategic position within the state. But such a cadre may already be engaged elsewhere, earning less money, and they go on. Then I just have regard to one last reference to the policy, and that is on page 74, where there is a lead-in from the previous page of 56, outlines of the policy were reviewed in June 2009, and they included cadres of the ANC should be ready to be deployed where the movement deemed it necessary to deploy them. And there's a couple of other bullet points. 56.3, deployees of the ANC should always be loyal to the organization. 56.4, I seem to have highlighted. The ANC should set clear standards to guide its deployees who are deployed at all levels and structures of government, which should apply to everyone without exception. And just on that, I'm going to turn to a fact which the ANC tried to explain away in a way which we submit doesn't do the job of any explanation. On page 412, attached to Dr. Schreiber's affidavit, founding affidavit, is a reference to, it's called LS1 in 412, an ANC region, the secretary of the region. And were the deployment policy to be okay, constitutional and statutory, this letter, this directive by the ANC region, secretary of the region, would fit in with that okay policy, that constitutional policy. But if your court is with us on our primary submission, the court will scratch its head with respect at how it could ever be that such a letter could even be contemplated, let alone written. Who is the letter to? Who is it from? And what does it say? Well, it's to all employees of the ANC in Chris Hani region. Now, the court will know that a region is made up of different district municipalities, as I understand it. That's under the municipal structures regime, under the constitution, but this is under the ANC regime, not the state regime. So it's to all the employees of the ANC. Sorry, so it's to all the employees. Then it says, municipal managers, CEOs of CHDA and CBC, all directors and all senior managers, from the regional secretary, that's the regional secretary, ANC Chris Hani branch. Date, 8 June 2022. That's just as we were launching this case. After all the evidence in the State Capture Commission, as Chief Justice Zondo was preparing his report. It says it's an invitation to a meeting with REC officials. REC means regional executive officials of the ANC. So these are ANC officials. These are not state officials, these are ANC officials. So who's invited? Municipal managers, CEOs of CHDA and CDC, all directors and senior managers, this is of the region, are invited to a meeting with the, let's call it the ANC regional officials. Receive warm inquiries to particular comrade or cadre with a cell phone number. Receive warm greetings. This serves to invite all the employees in management of municipalities and local government entities in this region to a meeting with ANC REC officials. Full stop. Next sentence and the couple of sentences are unfortunate. Municipal managers and CEOs have a responsibility to ensure the attendance of all senior managers in their respective municipalities and entities in the form of CHDA and CBC. The meeting will be held as follows: the date, the time, the venue, it's the casino. And then it says NB exclamation mark. No apologies will be expected. I suppose they meant accepted. Now, we find it I submit that it's the most unfortunate invitation. It's an invitation by political parties, to all municipal managers, CEOs in municipalities. And to attend or not to attend is not optional, effectively. So, can you imagine if the DA, I don't know if the DA have an office in that region, if the DA issued the same invitation to the same people, it would be laughable. Why is it not laughable when some other political party does it? And laughable in a constitutional sense, not a ha-ha sense. Not funny, it's serious. This is a consequence and part and parcel, this letter by the Secretary of the cadre deployment policy of the ANC, which I've just spoken.
Mr. Katz, can I take you back to the policy? When you were dealing with the policy, I thought you would deal with this point that okay. There is this debate that the committee either appoints, either dictates, either recommends. From reading of the text, because you are dealing with the policy, is there any clause in the text that will resolve that debate? In other words, can you point us to a clause that in your submission will show us that the policy does dictate?
I understand. I'll answer the question, if I may, in two ways. For our dictation, that's the B part of our argument. The A part is that recommendation is by itself bad. That's our primary argument. But if we are wrong on that, and that the problem is only dictation, we rely on the affidavits of the ANC and the President to show that what the ANC does is dictate, not recommend. But those are in the affidavits, which give life to the policy. I did want to make a point that, it's one point, and I'll leave it with the court, that I had said that the version of the ANC and the President concerning deployment in the private sphere on the facts are not identical, or they are inconsistent. If one has regard to the President's version, let me just make sure I'm right. Yes, no, this is the version of the ANC. So the ANC's version is on 457. And what the ANC were telling the court, what the ANC tells the court is its relation to what the President was telling the Zondo Commission. So the President, they say, the ANC says, made it clear that the deployment policy, and they made it clear, this is to the Zondo Commission, that the deployment policy has to be subordinate to the final selection process given, and this is the point to Justice Mopela, you're touching, I'll come back to it. But was it not for the work, and this is an important point, but was it not for the work of the African National Congress to ensure that those with a sensitivity to our past and a commitment to addressing historical injustice were deployed into the public service and to the boards of directors of state-owned enterprises? Then the important, I've made this point, I just want to highlight where it's in pleading. There would have been much slower change, as is evident in the private sector, where obviously the deployment committee has no influence. That's what the ANC told the court, that the President told the Zondo Commission. So the ANC accepts, it seems, that it has no influence in the private sector, even though its policy requires the media, business, etc., to be subject to this deployment policy. The President says, just the report makes a note, at 65.4 on page 631, this is the President's affidavit in this case. The cadre deployment policy applies to senior positions in government such as DGs and deputy DGs, as well as leadership of critical institutions, including the private sector. It does not apply to cabinet. And the simple proposition that I wish to make, the simple point that I wish to point out, is that the ANC say there needed to be change. One accepts that as a matter of principle. But the question is, how should that change go about? And surely the answer must be that the change goes about by having the political party put out its policies, it gets voted in, Parliament passes laws, Parliament chooses the President, President appoints cabinet, and those bodies, the National Assembly, members of the National Assembly, President and his cabinet, have a duty to the law and the Constitution which requires the type of transformation that the ANC talk about. It's not for a political party to do it. The law requires it. And one sees that. I don't know if the court needs me to even go to 197, 195 and Section 11 of the PSA. But the law requires it, not for the ANC to require it. And now I turn to some facts which to deal with Justice Montepela's concern, question, is where in the policy do I come to my B part, which is the question of dictation. Let me stop. Perhaps I should just close with part A. In our bundle 1, which I haven't got on the case line's reference, but page 1 and following deal with aspects of the Constitution, and in page 7 and 8 deal with sections 195 and 197 of the Constitution. And 195, it's in our heads of argument. We submit has various subclauses from A to F. And I just go to the last one, for current purposes. H, I, good human resource management, must be maximized, must be cultivated. And then it says public administration must be broadly representative of the South African people with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalance of the parts to achieve broad representation. And I've been banging on about that. It's what the ANC bang on about. But they say that they are the agents to be able to achieve that. And we say, no, it's the Constitution, it's the law that must achieve that. Not the ANC, not some other political party. The law achieves this question of balance. And then 197 over the next page, page 8. Public service. Within the public administration is a public service for the Republic which must function and be structured in terms of national legislation. And then the important point, and which must loyally execute the lawful policies of the government of the day. There's the requirement that the DG should be aligned with whatever is necessary to be done. And then one reads further, but it basically, if one turns onto the next page, one sees the Public Service Act, extract from it in any event. And in chapter 4, which starts on page 22, one sees mechanisms for obtaining services. In section 10, perhaps I should just, for purposes of this debate, sections 9 through to 11 deal with how public service persons are to be employed. Section 9, appointments in public service. An executive authority may appoint any person in his or her department in accordance with this Act and in such manner and on such conditions as may be prescribed. This qualification, the South African citizen or permanent resident, fit and proper person. In section 11, and Chief Justice Zondo, deputy at the time, the Commission, dealt with section 11 in some detail. In making any appointment in terms of section 9, all persons who apply and qualify shall be considered, and B, the evaluation of persons shall be based on training, skills, competence, knowledge, and the need to redress, in accordance with employment equity, the imbalances of the past to achieve a public service broadly representative of the South African people, including representation according to race, gender, and disability. And that's the statutory embodiment of what the Constitution requires. No need for the ANC or any other political party to say why they have the keys to speeding up so-called transformation when it comes to gender, race, and disability imbalances. And now I want to turn to I finished part A. We submit clearly the policy as a whole falls foul of what we would submit is the requirement that the appointment of public service officials shall not be tainted by recommendation ever of any political party. And I turn to part B. If we are wrong on that, I turn to Justice Mojapela's question about the question of dictation. And for this proposition, we turn to the affidavits of the ANC, which start for the current argument on page 431. In paragraph 58, there is a submission made, and I ask that the court tries to make sense of what he said, because we've struggled to make sense of the various paragraphs that are said, in the sense that the ANC says it doesn't dictate, it just recommends. That's what they tell the court. They put up various annexes and they say we don't dictate. And then they say various things which we invite the court to come to the conclusion that what they say is nothing other than dictation. So in paragraph 58, it says, if a state employer should, for example, choose to reject the Employment Committee's recommendation from a range of candidates, all of whom have established themselves as having the necessary qualifications, experience, etc., then, what then? So here, the ANC make a recommendation. They say it's not dictation, it's a recommendation. But they say if that state employee rejects the recommendation, then. Of course the ANC would want to know why the state employer chose someone who did not follow the recommendation. The duty to report and explain and decision to the party exists. if that isn't dictation, Justice Mojapela, what is? I recommend to you, the Justice Ledwaba, that you have rooibos tea rather than some other herb tea. You go along and you don't have rooibos tea. You say to your registrar, I want the other tea. You're free to choose whatever tea you want. But then I come along and they say, no, you have to explain to me why you rejected rooibos. And you've got to justify why you chose the tea that I didn't recommend. And let's see what happens. And if your explanation is not good enough, what then? Let's read on. In this notional example, the representative of the government employee who rejects a candidate recommended by the ANC, then obviously, if that representative was a member of the ANC, would have to explain their choice of someone other than the committee's recommended candidate. If their explanation was unacceptable, your explanation to me why you chose the other team, they might be disciplined by failing to implement party policy. But if they were convinced that the choice was the best for the job, and that despite the transformational objectives of the ANC, there was no better candidate, then the non-transformative appointment would be understood in the circumstances as a matter of practicality, and no disciplinary measures would be taken because the party respects and recognizes and respects the autonomy of the state. ANC says at the front of it now, it respects and recognizes the autonomy of the state. But if the state doesn't do what it recommends, what then?
If its member,
is a member.
if the member of the ANC,
Is the member.
not the state.
Yes, of course. And then we turn to page 434 to sum up page 86. The cadre is not necessarily a member of the ANC. It is the government's responsibility to select a suitably qualified person. The ANC makes a recommendation, they underline it, as to which of the qualifying persons available it considers appropriate because of its political and transformative policy. Now we know transformative we have no problem with. But the Constitution requires that. Whatever the word transformation might mean. Gender, race, disability, values. But political, we have a problem with that. What the ANC says. They say that it considers appropriate because of its political policy. Then, and the government is free to, and indeed obliged to, exercise independent evaluation of candidates to ensure the best person for the job is employed. That the correct application of the policy may require choosing someone other than the person who the party has recommended is a reality conceded by the national chairperson, a necessary element of government autonomy. When a choice that is made appears to contravene the party policy, then, as mentioned, the government employer's representative, if a member, and this is your point, Justice Ledwaba, may be called to account by the ANC for deviating from its recommendation making at a given appointment. If there was no justification, then disciplinary steps may have to follow for the member. That is party discipline, which is essential party politics. The discipline, where necessary, as a last resort, may be imposed. It is imposed only within the party. A range of disciplinary measures are appropriate, available, as appear from the rules of the ANC. The essential point is that discipline is within the party, just as Ledwaba, your point. It would not involve the person losing their position in the public service. The party has no role in the public servant's conditions of employment and not be presumed to exercise a role. And then we go on, the next page, 436. The application of the policy would not infringe on the independence and autonomy of the public service employee to choose the best person, provided the best person is understood to be a person who, along with having the necessary professionalism and employment qualifications required for the position advance the objectives of the transformation of our society. That may be because they are of a particularly historically disadvantaged sector of society that at the minimum, this is the important point, Justice Mojapela, at a minimum, they must share and live the values and ideals, not of the Constitution and the law, no, of the ANC and can be trusted to advance those values, ANC values, in their government position. If that isn't dictation, if that isn't unacceptable, then there is a blurring, we submit, of that which the Constitutional Assembly demanded as the distinction between party and state. Public servants should live and share the values and ideals of the Constitution. They're public servants, they're not ANC servants. But the ANC says to this court that these public servants, at a minimum, must share and live the values and ideals of the ANC, and can be trusted when they're sitting at Home Affairs, when they're sitting in Fisheries, when they're sitting at Water and Sanitation, when they're sitting at ESCOM, to advance the ANC values at ESCOM, at Home Affairs, at Fisheries. Justice Mojapela, if that isn't dictation of the kind which we submit on the papers, the ANC and the government find unacceptable, then we don't know what is. Because it seems to us that the ANC, quite correctly with respect, accept that dictation would be unacceptable. Yet what they do is dictation at large. So that's why, in our directions meeting, as I prepared the case, I came to the conclusion that this case is far narrower than the stack of papers. One, the ANC's own evidence, own legal conclusions given by evidence, is that it's constitutional to recommend. And we've made out I'm not going to read out into argument, we explain why recommending where the state employee who takes into account what a political party says in secret is unconstitutional. That's my part A. In alternative, the dictation, the ANC tell you, not in the front of their mouths, but in their paws, we dictate. We want our public servants to share and live the values and ideals of the African National Congress and be trusted to advance those values in their government positions.
We'll be adjourning in 10 minutes for tea. And about the duration of the argument, you indicated that it's done by corruptors. But if you need more time, just indicate that to us.
I'll just look through my notes and I'll give you an indication. Yes. What I propose to do, subject to taking instruction from my attorney and my junior who will give me advice rather than instruct me, I just want to suggest that the only thing that I'm going to deal with is remedy, and that's going to be less than 10 minutes. Now I'll just have a word with my two colleagues. I've got one point to make and I'll get to remedy. I've got one point to read from the affidavit.
Sorry to interrupt you, apologies to interrupt you, because your prayer one says we must declare the policy to be unconstitutional. So, as I understand your answer is that we should look at the evidence of the witnesses in order to reach that conclusion. Because I've asked you, if shouldn't we look at the policy itself?
Yes.
And a specific clause or a specific reading of the policy, and then juxtapose it against the Constitution,
Yes.
the provisions of the Constitution you say it offends.
Yes.
Shouldn't you guide us there?
Yes, I think I'm doing one that I thought I had, but the policy itself on its face. So one has, generally speaking, what your Lordship, Dr. Mojapela, is asking me if I understand it, is the policy on its face, without any evidence, constitutional or not? You can look at the policy, compare it to the Constitution, and come to the conclusion that it's good or bad. That, if I understand your question. That, to our mind, the first proposition, look at the policy and read it with regard to the legal arguments about Section 195, 197, and Section 11 in particular of the PSA, and you will come to the conclusion we submit that this policy is bad. For the reasons that we've advanced in the founding affidavit, in the replying affidavit, and in our heads of argument. If you come to the conclusion that you can't agree with us on that facial argument, in other words, that the policy on its face is bad, then you go to the evidence. What does the ANC say? What does the President say? What do the minutes of the ANC say? And then you come to not alternative, but the secondary challenge, which is that the policy properly interpreted and properly applied is bad. And we get the same result, which is 1, 2, and 3.
So in other words, there is a document, then the court should rely on the witnesses to interpret that document. So the court shouldn't interpret that document itself.
Well, it can as a primary submission. Our primary submission is you don't have to look at the evidence. You can look at that document and come to the conclusion. So let's say you've got a section of an act. Let's talk about legislation, for example. Let's say you've got a piece of legislation which says Criminal Procedure Act, and I'll follow Justice Ledwaba's lead, and the section says those guilty of treason shall be subject to the death penalty. The court, in considering the constitutionality of that provision of the Criminal Procedure Act, will look, is the death penalty and is the section constitutional without having regard to evidence? It doesn't matter what the person did. Treason, murder, mass murder, or terrorism, or war crimes. Is the death penalty on its face good or bad? That's the primary role of it. On its face, is that section good? Now, of course, when it comes to rights violation, there's a requirement on the body that relies on the challenged legislation, if it does violate rights, to leave evidence, what is called legislative evidence. I'll go back to the days of Hogg, Canadian jurisprudence, as to why that section is justifiable under Section 36 of the Constitution, as a matter of constitutional principle. And we say the same here. We have a policy, not we, there is a policy that is challenged. The court will look at that policy and say, well, is it okay, constitutionally, for the ANC to take over key centers of power, including judicial and investigative functions? We would say you don't need evidence to come to a conclusion that the ANC deploy persons in the judiciary and in investigative police walks, etc. You don't need any evidence to come to a conclusion that it's unconstitutional. But if you reject that primary submission, then you go to the evidence and say, what actually happened? What did the ANC say about the policy? What does the government say about the policy? For some reason they're here. And you will come to the conclusion, as I've just read to you those paragraphs. Follow our recommendation or else we will discipline you. We, the party, will discipline you if you're a member of our party. Is that not dictation? And that goes to the question that the ANC would accept. If implicitly they accept. If what they do is dictation, it falls foul. That's Constitutional Law 101. It's not Corruption 101, it's Constitutional Law 101. Dictation of...
Sorry to interrupt you. Please complete your sentence.
Excuse me?
Please, you can complete what you wanted to say.
Now, I've said that the question of dictation, so that in other words, when a minister has the power entrusted upon him or her to appoint a DG, for example, and he or she is dictated to by anybody, that dictation amounts to a fettering of his or her discretion, and there's nobody, I don't think, who would argue that fettering, the dictation point, is unconstitutional or lawful. That point was made in SAFU, it's Constitutional Law 101, not the comparison with cadre deployment and corruption, the 101. That we submit, and we submit on these facts, on the Hogg line, legislative facts. Hogg is the Canadian professor who wrote about, who construed the idea of the notion of legislative facts with justifying a violation of rights. So there's a piece of legislation, and the government defend the piece of legislation, they need to put up legislative facts. So in Sunday trading, when it comes to liquor laws, they've got to put up evidence as to why, if you don't limit trading on a Sunday, there could be problems with gender-based violence or violation of churches, whatever it is, it's legislative facts. Here, There is a policy
Be-
which on
Before
its
you,
face.
before you go on the policy, I think my colleague wanted to put something.
I'm struggling with this dichotomy of a policy document vis-a-vis human conduct.
Yes, I
What I've been listening to since this morning is human conduct.
Yes.
And I would like you to help me understand, are we dealing with human conduct here? Whether misguided in the way the person understands the policy or whatever. Or are we looking at the policy and saying, this is the issue, this is the source of the evil.
Yes.
And I cannot get the answer.
I do apologize.
I think it was asked at some point.
I apologize if I haven't
Forgive me if I heard you incorrectly, but I think many of the examples, many of the statements that were made relates to human conduct
Absolutely not.
as opposed to the document
No, I accept
itself.
that. I accept that. I accept, and I apologize. Let me go back to my introduction, and hopefully I can clarify. Hopefully. If I haven't, then please pressurize me. Our primary submission, is that the court will look at the document without human conduct and come to a conclusion that the document itself, the policy document itself, is inconsistent with the Constitution and invalid. The primary. So let me go back. Let me stand back. This morning, I made the point that there are two parts to our argument. The one is the A part, which is recommendation, and B part, which is dictation. So perhaps I wasn't clear as far as the A part is concerned. The court can look at the document and come to a conclusion that the document itself talks about recommendation. That's what it's about. And come to a conclusion on the document itself, it violates the constitutional prohibition on recommending. Justice Plum, the document itself, no human conduct, the document, the policy, the facial, take the words in the document. Take the words where the party says, we are here to deploy cadres, these aren't how it's put, but we are here to deploy our cadres to the judiciary, to the investigation functions of state, to the media, to the business, to all levers of state. That's what the document says. You don't need to go to see how what anybody's done or anything. That's good enough in our submission to come to a conclusion that prayers 1, 2, and 3 ought to be granted. If you're not with us, still part of Part A, you look at, well, how does the implementers of the policy, the ANC, leave aside the government for a moment, how do they see the document? And we submit that they see the document as doing what we say that it does, but that it goes further than that. Because there's a crossover, and I understand your concern, Justice Plum. There's a crossover to Part B, which is the dictation argument. So if there's a line between A, which is recommend, and B, which is dictation, if one looks at what the ANC says, on its lips, remember George Bush saying, read my lips, no new taxes. Read my lips, the ANC says, no dictation, recommend only. That's good enough for us to win. But if you go behind what they're saying, you go to not their lips, but what they do, then we come home on dictation. Part B. I hope that I've been better explaining.
Yeah, I'm going to, the court is going to adjourn now, and if you need to amplify, you can amplify that. I think we'll give you maybe another 15 minutes. I think you'll be able to wrap up your arguments in another 15.
Thank you, Master.
Thank you. Court adjourns. 15 minutes?
15 minutes.
Thank you. You may proceed.
Over the tea break, I cogitated on how I answered Justice Bum's question, and I feel I didn't do justice to the question. So let me try once again to describe how we see the difficulty. I've made the point that there are two parts. The first part is this question of recommend. Let's call that the recommending part A. If the court is with us, that's the end of the case, as far as the respondents are concerned. But if we are wrong, that recommending by a political party in the appointment of a public official is constitutional, then we say, on the facts, there's a dictation. And that's part B. And your ladyship asked me, quite correctly, and we think quite appropriately, how do the words on the policy and the evidence square with this A and B part? And I gave an answer which wasn't a complete answer in my view. And let me try to give a complete answer. As far as part A is concerned, there are two subdivisions, two tributaries to this river. The first is, the court is welcome to look at the policy on its face and come to a conclusion that it violates the conclusion. The second tributary is to look at the policy together with what the ANC says the policy does in its affidavits, tributary 2. This is still part of part A, and come to a conclusion that we're entitled to 1, 2, and 3. So one looks at the policy not just in tributary 2 on the face of the words of the document, but on the words as interpreted and given life by the ANC itself. And the ANC comes to this court and says, these are the words, but this is what we say the words mean. And you will look at what they say, and I've explained it to you, and you will come to a conclusion with respect that that understanding of the policy falls foul under my part A. Part B, I've said, read my lips. We don't dictate. We just recommend. And then they tell you what they do. And this is the first George Bush. Read my lips. And read my lips turns to page 449. And you will see on the facts a short description of a content analysis report of the 85 recommendations made by the Deployment Committee in paragraph 111. Of the 85 recommendations made by the Employment Committee, 111.2, this is on page 449, the Deployment Committee accepted 56 of the recommendations as presented. I'm not sure, there might be a typo. 19 were referred back for greater representation, 6 were referred back or rejected for process to be followed, and 4 were referred back for women representation. And in the next paragraph, and we ask that the court has regard to what's said in 112, there are different channels of state employment. The processes of appointment within each channel are different. And then the important sentence they suggest, the ANC suggests, the Deployment Committee does not make recommendations where purely political appointments are under consideration. What does that mean? It means the Deployment Committee does make recommendations when non-political, apolitical appointments are to be made. We submit, that's like one of those towers, I don't know if you're in Cape Town, there were those Athlone towers, and I think the city wanted to have them removed. And what did it do? It imploded them. And when the ANC says to the court, it does not make recommendations where purely political appointments are consideration, other side, it does make recommendations where non-apolitical appointments are made. That's like an implosion of their own argument. So I want to turn now to remedy. Justice Ledwaba, you put to me, are there alternative remedial possibilities? And yes, there are. And then the rejoinder to the yes, there are. But so what? We're not seeking an interdict. We're seeking declarators. And when it comes to declaratory relief, 172, we would submit, govern how the court considers what to give. This is not one of those interdicts, well, you can rather...
Even in a declaration, the court should look as to whether it's one of the factors that should be considered, whether there are other remedies.
We would submit not.
There's a lot. Anyway.
Well, it depends on the nature of the declaration. If the declaratory is one under... The declaratory that we seek is one under 172(1)A. So it's a declarator that says that that particular, in this case, policy is invalid and unconstitutional. What you could do with respect is you could, it's open to the court under, for example, prayer 1, declare the first respondent's policy, cadre deployment policy, to be inconsistent with the Constitution and invalid, and then you could add, we submit that there's no reason for you to add, you could add, to the extent that, and what you find it does wrong. Because that's what section 172(1)A actually talks to. You declare the inconsistency, and you declare the invalidity to the extent that. So, for example, you could say, declaring the policy inconsistent with the Constitution and invalid to the extent that it goes further than recommending, or however the court comes to its view. But we submit there's no need for that in this case, and there's no suggestion by our learned friends for any of the parties that such would be an appropriate order, or that there should be a limiting of the declaratory effect. Let me just talk about the alternative remedy. So that's as on the matter of principle, why we submit that the alternative remedy shouldn't have played any role in the court's consideration. But on a practical level, I'll tell a story, if I may, and then I'll end. And the story relates to one of the first cases that the DA ever brought of this kind. The DA had been litigating, but it never litigated of the kind that we now see. The litigation that had been involved in were, for example, members of the DA had been disciplined and removed from the party, and they lost their public seat and had to litigate one way or the other. But the first case that they ever did, the question of standing arose very clearly, and jurisdiction, was the Democratic Alliance versus the President of the Republic of South Africa, 2013, Volume 1, SA 248, Constitutional Court, where Yaqub J. DA versus President.
2013, Volume 1, SA
248. It's what I'm going to call the Similani case. And the story goes like this. The National Director of Public Prosecutions, Mr. Advocate Vusi Bikoli, had, in the court, perhaps I'm too old, but had, under the Jackie Selebe scandal, ceased to be the NDPP under the presidency of President Mbeki. And now the new president came in, President Zuma, and the president, one of the first things that he did, leave aside then Nkandla, which was the second thing that he did, which was develop Nkandla, but the first thing that he did was to appoint the new NDPP, who was Advocate Menzi Similani. And the DA looked at this shortly after the inauguration of President Zuma and took the view that the appointment was unlawful. But it had no facts. How would it challenge an appointment when it didn't know what President Zuma had looked at, had not looked at? The other candidates now know years later. But anyway, we now know how the current president appointed the current NDPP. But the point was, could the DA litigate in the dark about a particular appointment? And I say in the dark, because that would be effectively what it would be litigating about, were it to take the view that the next CEO of Eskom or whoever had been unlawfully appointed because of the appointment being one made inter alia on the recommendation through the application of the deployment committee. If there are 100 or more deployees in senior government positions, how would the DA know, or how would, not the DA, how would anybody know that there is this blurring between state and party in any particular case? And one can have regard to this point that I'm just referred to a little while ago, the 449, paragraph 111, 112. Nobody knows. It's in secret. Your Lordship put to me the minister who's a member of the ANC, who sits at an ANC meeting, and he hears what the ANC are saying about that particular deployee or cadre or comrade or whatever. We just don't know. But as a matter of principle, that minister should recuse himself from the ANC meeting when it comes to state business. When it comes to ANC business, he's fully entitled to be there. But when it comes to state business, his role is not to listen and have regard to it. The President himself recognized this. The Zondo Commission recognized the President gave evidence twice. Once in his capacity as leader of the ANC, and once in his capacity as leader of the government. They wear different hats. That's what the Constitutional Assembly demanded of the public service. And that's what the DA comes to this court to demand, or submit, rather than demand, the relief that entrenches that principle of we are not a one-party state. We are not a state which is the party. We are a state where there is a separation between the party and the state. An ANC minister is good. There's a minister from a party not a member of the ANC, we understand. One of the cabinet ministers is not, or at least one, there may be others, who are not a member of the ANC. It's not appropriate for her to go and sit in on her party and listen to what her party says should happen in I think it's public works. She must do what's good for the state, not good for the good party. And there I'm deep politicized here. I'm not talking about the ANC. I'm not talking about the DA. It would be highly inappropriate for Mr. Lowe to have regard to what the good party says is good for anything. She must do what's good for the state. And that just exemplifies the difficulty here. It's not about the ANC or the DA. It's about principle. No political party should have any influence on who gets appointed to serve the public. And we submit that 1, 2, and 3 should be granted with costs of 2 counsel, as it pleases the court.
Thank you very much.
Thank you.
You may proceed.
May it please the court. I'll be making reference to my heads of argument, which can be found at section 6, page 69 of the case lines bundle. I'd like to start with a famous proclamation of Lord Acton. Power tends to corrupt, and absolute power corrupts absolutely. The ANC's counter-deployment policy unashamedly exposes the party's ambitions to seize total control over every aspect of the state. My learned friend Mr. Katz has delineated in detail what paragraph 10 of the policy aims to achieve. It lists all of the different aspects of the state in which it wants to seize power over. But the state is not enough for the party. Just like for Bond villains, the world is not enough. Its lust for power extends to the media, businesses in all major sectors, and even religious, sporting, and cultural bodies. It wants to wrap its tentacles around everything in South African life. And to avoid ever being held accountable, the minutes of the Deployment Committee even sketch out a mechanism to undermine the independence of the judiciary. The minutes describe the current process of appointing judges as incestuous, since it provides for a system that has the judiciary having too much power in determining the leadership. And we see this echoed in the arguments raised by the respondents, in that they say this court shouldn't have power over this case. It shouldn't be able to decide. The findings of the State Capture Commission make it abundantly clear that it would be unconstitutional for the government to act on the instructions of the ANC Deployment Committee. The report states the following. Within the current constitutional and statutory framework, it is unlawful and unconstitutional for a president of this country and any minister, deputy minister, or director general, or other government official, including those in parastatals, to take into account recommendations of the ANC Deployment Committee or any similar committee of any other political party in deciding who should be appointed to a position in the public service in organs of state or parastatals. Now, in the government's heads of argument, at section 6, page 129, at paragraph 131, it stated that consideration of the Deployment Committee's recommendations or resolutions would be a contravention of the memorandum of incorporation of the PMFA of the minister. So they give an example of when it would be unlawful for the minister to act on these recommendations. The ANC itself, at section 6, page 102, in its heads of arguments at paragraph 30, says the party policy recognizes the limits of its reach and it cannot encourage government to breach its duties. So it's accepted that there is a duty on government not to listen to the recommendations of the ANC's cadre deployment committee. And the ANC itself accepts that it cannot encourage government to breach its duties. But that is exactly what the aim of the policy is. The aim of the policy is to whisper in government's ear and say, pick this person. And when you come to ANC meetings and you're wearing your ANC hat and you didn't listen to our recommendations, there will be consequences. Both the government and the ANC are parties to an unlawful practice. The government is akin to a thief for hire, and the ANC is akin to the criminal network ordering the theft. And unfortunately, it is the South African public that has been stolen from. The amicus supports the relief sought by the applicants and will focus on 5 issues in the submission. Firstly, to talk about the devastating effects on the economy, with the poorest of the poor feeling those effects most dramatically. Secondly, that the policy violates the rule of law. Third, that it violates the value of non-racialism, which is in section 1 of our constitution and seen as a foundational value. Fourth, that it amounts to unfair discrimination on the grounds of race, belief and conscience. And fifth, that the attempts to control the press undermines press freedom. Now, my little friend Mr. Katz is right to say that this court must look at what the legal obligations are. But it would be remiss of me not to mention the economic devastation, to look at the real world effects of this policy. Barbara Hogan's testimony at the Commission describes the vast asset bases and strategic importance of Eskom, Transnet and SAA. She says if Transnet does not work, none of us work. Eskom is responsible for 97% of the electricity generation, and we have all experienced the consequences of its failure with widespread blackouts. She underlines the need to have the best of the best on the boards of the SOEs. So where do we find ourselves? Last year there were 220 days of load shedding. Every single day of this year there has been load shedding. Now it's not just unpleasant to work in the dark, not be able to cook your meals. The economic impact on small businesses is absolutely sickening. It should fill all of us with a deep sense of nausea that people who are just trying to feed their families cannot do so because there is not power in this country. It goes so far, it's so embarrassing that one of the busiest divisions in Gauteng, the Johannesburg High Court, has to close its doors to physical court appearances because there is not enough power to supply people with access to the courts. And there is furthermore talk that for the next 2 years we will have load shedding every single day. Now the idea that we should be appointing the best of the best is exactly what we should be doing. It's not what's being done. What's being done is that the ANC have appointed people that suit their interests, sectarian interests, not the interests of the South African public.
The ANC that appointed them, or is it the state?
I beg your pardon, my lord?
Were those people appointed by the ANC?
Well, my lord, the ANC whispers into government's ears and says, pick these people.
But ultimately they are appointed by the state.
Yes, yes, of course. The ANC acknowledges that it has no actual appointment powers. No piece of legislation gives it those appointment powers. It is only the state that has the actual power to appoint. And what they've done is abdicate responsibility. Instead of being the ones that are doing the appointments, they go to an ANC meeting and they say, who's on the agenda list? Let's look at the minutes. Who do you want? Which judges do you want? Which deployees do you want? Are they members of the ANC? Oh, wonderful. The minutes are replete of examples where it's celebrated that so-and-so is a high-ranking member of the ANC, and of course they'd be wonderful for this board. No mention of their qualifications, no mention of what they could do in that position, but their membership in the ANC is seen as a very good reason for appointing them. And that's that dereliction of duty by the state. President Ramaphosa admits that the ANC is corroded by corruption, although this only seems to be of concern because this has affected the party's electoral support. The fact that billions of rands have been looted, the economy has been wrecked, millions have been driven into unemployment, doesn't appear to be of concern. Barbara Hogan's testimony at the Commission illustrates the damage done to the country because of the government's adherence to the ANC's deployment policy. She describes the deployment policy as a clandestine one carried out by a handful of people who've abused their power to usurp executive authority. She says the way to pursue your career is to walk a beaten path to the Tulu House and ingratiate yourself with the party. In other words, it's not become excellent in a particular domain. Work your way up through a meritocracy and work out, how to run Eskom or Transnet. No, it's to ingratiate yourself with the political party. The Deployment Committee minutes demonstrate that the committee not only has the power to place people in positions of authority, but also to have them stripped of their position. They explicitly state the need to remove Nazir Ali, the founding CEO of SANRAL, because he's proven to be dogmatic. That shows the enormous power that the ANC has to say, we don't like this person, government must remove him. The report makes it clear that cadre deployment subverts the rule of law by ensuring that real decisions are made by the party instead of those who have the lawful authority to make them. The report states the following. The Commission has heard substantial evidence indicating that multiple appointments were made to key positions in order to facilitate state capture. Those appointments were all made by the National Executive, who, except for the President in some cases, were as members of the ANC bound to the party's deployment policy. The fact that the ministers seek to convince the committee and go through such lengths to do so implies that the true and ultimate decision-making power lies with the committee itself. So the point that I made earlier is echoed by the Zondo Commission report. Government has absolved itself of responsibility to make the appointments and says, what does the ANC have to say on the matter? The party is where the real decisions are made. President Ramaphosa concedes that the party is where the power resides, again quoting from the Zondo Commission. Appointments in the public service sector are governed by a number of laws and policies, most significantly the Public Service Act, which seeks to ensure that the appointment processes are fair, effective and in line with the Constitution. If appointment decisions are not made with this governance regime, but rather made behind closed doors of the party, these checks and balances are circumvented. On this point of the closed doors, these decisions are made in secret. The idea that the party is merely expressing its free speech.
Decisions or recommendations?
Beg your pardon?
Are the decisions or the recommendations made in secret?
The recommendations are made in secret.
Yes.
The actual appointment would, of course, have to be done in public by a government. But the whispering in the ears, the recommendations, are now strong recommendations because there are consequences if you don't abide by them. Those are made in secret. There's this line that, well, if the policy was declared unconstitutional, it would be infringing on the party's free speech rights. The party is not publicly saying, we think the following people would make wonderful deployees at the SCOs, and then inviting some kind of discussion or debate or deliberation, allowing the public to engage with the ideas and saying, well, we make recommendations like anyone else can. This is a very different process. This is a clandestine process. This is whispering in people's ears behind closed doors. That's not an exercise of free speech rights. That's an exercise in coercion. The report goes on to say, furthermore, if the party does have the power to decide appointments, the concern is that the party can abuse this power to achieve ends which are not in the best interest of the country. If the party prioritizes loyalty or party membership as selection criteria, there is a risk that it will not select the best person for the job, and moreover that deployees will serve the interests of the party even to the detriments of the country. This is not just an abstract concern, this is an actual concern that all of us are living through. The best were not picked. Those that ingratiated themselves with the ANC have prospered. The rest of us have not. Now, the learned authors of the Constitutional Law of South Africa state the following about the rule of law and the separation of powers.
Okay, Mr. Oppenheimer, I see you reading verbatim what you see in your case. We have read your case.
Yes.
So I don't think it's necessary.
I won't read verbatim, but I'll go into I'll read the relevant extracts, my lord. The idea behind the separation of powers is that you cannot have all power concentrated in one body. The idea that you can have a benign dictator who will be able to, rule with wisdom and justice just isn't borne out through historical evidence. And so it's important that you separate out these powers. Now what we have is the ANC removing this separation between the party and the state, that instead of you having a proper process where there's a delegation of power and a delegation of authority, you have the party usurping that power. The rule of law, in essence, means the absence of arbitrary power. It encompasses the view that no person in authority enjoys wide, unlimited discretionary or arbitrary powers, and the fundamental notion of equality before the law, which means that every person, whatever their station is in life, is subject to the ordinary law and jurisdiction of the courts. The ANC has granted itself powers that it does not have. It has destroyed this distinction between the party and the state. Like Orwell's pigs in Animal Farm, they have proclaimed themselves more equal than others. They have upended the rule of law for their own benefits and to the detriment of the nation. Now, I mentioned earlier this value of non-racialism, which is entrenched in Section 1 of the Constitution, and we see how it has been abandoned by the ANC in their policy document and in their minutes. The minutes are replete with references to the race of the candidates. Often, when particular members are brought up for consideration or recommendation, it is their race overall that is mentioned. There's something...
Direct me to parts which mention that when recommendations were made, race played a role. Because even when you look at the papers of the applicants, they don't mention that the ANC, this policy should be declared unconstitutional because ANC takes decisions based on race.
Well, my lord, the PSA itself makes reference to equality and the fundamental values of the Constitution in Section 11. Non-racialism is one of those entrenched values. Non-racialism is this idea that we judge each other based on the content of our characters, not the color of our skin. And if we look through what is done in the minutes, we can see that time and time again what is mentioned is the race of the candidates, that the color of their skin matters more than their abilities, than the content of their character, their ability to do the job, to serve the nation.
I requested that you can direct me to the minutes where
my lord, at
they
page
say that the people should be appointed because of their race.
At section 2, 386, there is an example of this. So, for example, at paragraph 5, the GCIS Director General, Comrade Jackson Mtembu presented the 27 applicants for the position. From the 27, 6 were shortlisted, 2 were female and 4 were men. All were African, and with the exception of one male who was Indian. Preferred candidate was female, with the deployment committee agreed on. It then goes on to list, for ICASA, there were 75 applicants for the permission. 10 names were presented, which only 3 were females. In the road traffic, it says the post had 50 applicants, presented 5, including 3 male and 2 female, 1 Indian, 1 male was Indian, all the other applicants were African. So there's this emphasis on race, to say This is what matters, and that runs contrary to our constitutional values of non-racialism. Now, the policy itself, this is at clause 4 of the policy, refers to deracializing the public sector. Now, there's an ambiguity what's meant by the term deracializing. One is the constitutional interpretation, which is that race will no longer play a role in determining whether or not you will be appointed. That would be a constitutional interpretation. But that's not what we see. It appears to be the case that it's about eradicating certain races from the sector. And so that has the more pernicious interpretation. It appears to be what's done, which is that those who were here before, who are not in the new favoured racial group, will be removed. That if you're in a minority racial group, if you're classified by the state as white or Indian or coloured, well then you'll be deracialised from the public civil service, that you don't have a place here. Now that flies in the face of this value of non-racialism. To give some more historical significance to this value of non-racialism, we can look at something like the Freedom Charter, which proclaims the following. South Africa belongs to all who live in it, black and white. The rights of the people shall be the same, regardless of race. All national groups shall have equal rights. All shall be equal before the law, and all laws which discriminate on the grounds of race shall be repealed. The ANC itself in 1991 produced a document called Constitutional Principles for a Democratic South Africa. It proclaimed that a non-racial South Africa means a South Africa in which all the artificial barriers and assumptions which kept people apart and maintained domination are removed. In its negative sense, non-racial means the elimination of all colour bars. In positive terms, it means the affirmation of equal rights for all. Our case law is also replete with examples of this idea that non-racialism is a fundamental value. Judge Sachs, in the Van Heerden matter, says that it is important to ensure that the process of achieving equity is conducted in such a way that the baby of non-racialism is not thrown out with the bathwater of remedial action. And in the Walker case, Judge Sachs says that no members of a racial group should be made to feel that they do not deserve equal concern, respect, and consideration, and the law is likely to be used against them more harshly than others belonging to other racial groups. In the Barnard case, Judge Cameron stated that if we want to achieve the magnificent breadth of our Constitution's promise of equality and freedom from disadvantage, we must foresee a time when we can look beyond race. Now, the Deployment Committee's obsession with the race of potential candidates undermines this value of non-racialism and cannot be countenanced. With regards to unfair discrimination, as I mentioned earlier, Section 11 of the PSA makes explicit reference to the democratic values and principles enshrined in the Constitution and references equality. In the making of appointments and the filing of posts in the public service, due regard shall be had to equality. Now, to understand what's meant by equality, we can have a look at Section 9 of the Constitution, which gives us an indication of under what circumstances people must be treated equally. As I stated earlier, if we look through the minutes, what is celebrated is not merit. It's whether the person is a member of the ANC. For example, deciding who should be appointed to the Nuclear Energy Board, much delight is taken in the fact that the chair is a long-standing member of the ANC and all of the members are from the ANC. Candidates who are not members of the ANC have no chance of securing the recommendation of the Deployment Committee, and this means that they're engaged in an unfair and unequal competition. This is from the report. The benefit to the ANC of the committee is that the ANC individuals who get appointed will feel grateful to the party for giving them such jobs. They may strengthen their loyalty to the party and make them beholden to the party. This is highly undesirable because such an official should put the interests of the people of South Africa first, and there should be no risk that he or she may put the interests of the party above those of the country or the people. Now, what the Constitution says that the state cannot discriminate and individuals cannot discriminate, so it binds the ANC on the grounds of race, on the grounds of belief, on the grounds of conscience. What we see here is that if you're a member of the ANC, if you believe that the ANC is the true party of liberation and you want to support them, well then you can be considered. If you don't believe that, if your conscience says, I cannot accept the values of the ANC, I support a different political party, or you're of a different race that's not favoured, well then you will be discriminated against. Now, the ANC itself, in 2001, saw some of the dangers of its cadre deployment policy, and the report quotes from the ANC's Eye of the Needle. It says, because leadership and structures of the ANC affords opportunities to assume positions of authority in government, some individuals then compete for the ANC leadership positions in order to get into government. Many such members view positions in government as a source of material riches for themselves. Thus, resources, prestige and authority of government positions become the driving force in competition for leadership positions in the ANC. Government positions also go hand in hand with the possibility to issue contracts to commercial companies. Some of these companies identify ANC members that they can promote in ANC structures and into government, so they can get contracts by hook or by crook. Positions also in government also mean the possibility to appoint individuals in all kinds of capacities. As such, members make promises to friends that once elected and ensconced in government, they would return the favour. Cliques and factions then emerge in the movement around personal loyalties driven by corrupt intentions, members becoming voting fodder to serve individuals' self-interest. Therein lies the rub. The ANC itself acknowledges that when people are placed into positions of power, when it whispers in government's ear and says, appoint these people, it's not doing so for pure motives. It's saying, well, you help me out here, I'll help you out here. Oh, you're going to be able to issue contracts? Well, these are my friends who would benefit from it. And that means that instead of picking the best and the brightest, you're picking people that are loyal to the movement, and that's why we have the economic crisis that we have. That's why you have substandard coal being put into Eskom power plants. That's why we can't keep the lights on. That's why the economy is in shambles. Now, I mentioned that one of the factors for the unfair discrimination is this idea of indirect racial discrimination. The Constitution doesn't just prohibit direct racial discrimination or discrimination on any of the listed grounds, but indirect as well. And in the case of Leonard Dingler, the court held that indirect race discrimination occurs when criteria, conditions, or policies are applied which appear to be neutral, but which adversely affect a disproportionate number of a certain race group in circumstances that are not justifiable. As with direct discrimination, intention or motive is irrelevant. In the Walker case, the Constitutional Court held that conduct which differentiates between the treatment of residents of townships which are historically black areas and those residents which are overwhelmingly black, and residents in municipalities that are historically white areas and whose residents are still overwhelmingly white, constitutes indirect discrimination on the grounds of race. Now, the point of that is to say you can have a policy which doesn't mention race, but which implicitly has this disparate impact. So, those who support parties other than the ANC are unlikely to be appointed by the Deployment Committee of Government. Deciding which political party to become a member of is intimately tied to one's conscience and beliefs. Therefore, the party discriminates on those grounds. With regards to race, historically the ANC was a multiracial party. It had members from all different racial groups. However, it has become abundantly clear that those categorized as white or Indian or colored have been sidelined within the organization. If we look at the
ANC now consists of only blacks.
Well, my lord, if we look at the NEC, the top seven.
I'm not talking about the NEC, I'm talking about the ANC, and that is what you just read out.
The NEC, well, the National Executive Committee of the ANC. In other words, there's 87 people, there's the top seven, and there's 80 others. Of the top seven, all would be categorized as black. in the 80, there is Tina Jamaat Peterson, who would be considered...
The question I raise is in respect of what you just read out to us. That the ANC was a multiracial political party with members from all racial groups. However, it is now clear that those categorized as white have been sidelined within the organization.
Yes, within the organization of the ANC.
What I want, the clarity that I'm seeking from you is that, are you saying that in the organizations of the ANC, it's only blacks?
No, I'm going to give the exact breakdown. It's almost entirely that way. In the top 7, there are no white people, there are no Indian people, and there are no colored people. In the bottom 80, there is one white person, being Barbara Creasy, and there is Tina Jamaat Peterson, who would be classified as colored. Of the other 78, all are black.
Okay.
So in other words, it doesn't have to be the case that they have such a rule, which is that we're a party only for people of a certain race. It just is the case that people who do not share a certain racial group have been sidelined within the party. And it's not just white people, as I point out. People that are classified as Indian or people that are classified as colored have also been sidelined. And so if the party is saying one of the things that matters for your deployment by government is that you have ANC membership, and if it is the case that the ANC has conducted itself in such a manner that it sidelined people of certain racial groups, well then there's indirect racial discrimination. Finally, the cadre deployment policy explicitly seeks to take control over the media. This is in paragraph 11 of the cadre deployment policy. And Mr. Mantashe proudly told the Commission that the ANC fostered a relationship with the Gupta family to create ANC and the New Age to disseminate information that was favourable to the ANC. He goes into some detail about how this relationship was formed and why they thought it was important to have their own newspaper that would push forward a pro-ANC agenda. Now, the media is often described as that fourth branch of government, that it has this obligation to hold the powerful to account, that it should be truly independent, that it shouldn't have party hacks inside of its ranks, that it is free to be able to report on the misdeeds of a political party and the misdeeds of government. In Kholomisa, the court held that the success of our constitutional venture depends upon robust criticism of the exercise of power. This requires alert and critical citizens, but strong and independent newspapers, journals and broadcast media are needed also. If those criticisms are to be effectively voiced and they are to be informed with the factual content and critical perspectives that investigative journalism may provide. Now, the New Age and ANC are far cries from independent press. They're set up by the ANC in line with the infamous Gupta family to push an ANC agenda and mislead the public. In the Kamala case, the Constitutional Court held that in a democratic society, the mass media play a role of undeniable importance. They bear an obligation to provide citizens with information, which is critical to the development of a democratic culture. If citizens want to deliberate about what's going on, they need to have access to accurate information, not propaganda. As primary agents of the dissemination of information and ideas, they are inevitably extremely powerful institutions in a democracy, and they have a constitutional duty to act with vigor, courage, integrity, and responsibility. The manner in which the media carry out their constitutional mandate will have a significant impact on the development of our democratic society. If the media are scrupulous and reliable in the performance of their constitutional obligations, they will invigorate and strengthen our fledgling democracy. If they vacillate in the performance of their duties, the constitutional goals will be imperiled. This line of cases recognizes the importance of an independent press, and the report shows that the ANC tried to undermine this idea of an independent press by setting up its own parallel structures. And the policy itself says this is our goal. When we are looking at all the levels of state power to control, we're not just satisfied with the state. We want the media too. We want business, we want sports, we want culture. In conclusion, It makes it much easier to engage in state capture if the watchful eye of the media has been blinded. It's part of the tactic is to say, how do we hide our sins while we erode the freedom of the press? We have our own parallel structures, and the citizens won't know what we've actually been up to. Both government and the ANC have shown themselves to be complicit in subverting the fundamental tenets of the Constitution, and it's vital that this honourable court shows its disdain for the actions of the respondents by granting relief sought by the applicant. Now, there's been some discussion about which sections of the policy could be looked at. There's an argument that the policy as a whole implies what the ANC's agenda is. However, I think the specific emphasis could be had on sections 8 to 12, which set out how the deployments must happen, which areas must be captured. Those are the sections of the policy that strike me as the most pernicious. They're the driving engine. I think my learned friend, Mr. Katz, is right to say that the policy is the root problem. Justice Bum described it as the root evil. That the policy is what enables the human action. The policy on its own can be determined to be unconstitutional. The human action stems from the policy. The human action where individual members of the ANC will sit, will have their committee meetings, will then recommend to government who ought to be deployed, and if those recommendations are ignored, well, then there'll be consequences. That human action is obviously a problem, but it stems from the policy itself. The policy itself can be understood on its own terms, that a clear reading of the policy shows that it's unconstitutional and unlawful. And of course, the evidence at the Zondo Commission amplifies this. It gives examples of how it is actually done, and that can be used to supplement the case. I have no further submissions.
Thank you, Mr. Oppenheimer. I see your case is that your client supports the relief sought by the applicant. In other words, that the policy is unconstitutional. And I see mostly you rely on discrimination and you emphasize race. There is a complaint, and you'll tell me whether this complaint is valid, that when you are challenging a constitutional, when you are raising a constitutional challenge, you are not entitled to go directly to the Constitution, but to a legislation, to a subsidiary legislation. Firstly, you must tell me whether that's a valid complaint. And secondly, whether is there any reason why the challenge is not directed in terms of PEPUDA, the enabling legislation, but is going directly to the Constitution?
Yes, Justice. The principle of subsidiarity is the correct principle. You can't rely directly on the Constitution, but you're not obliged to go the route of PEPUDA. As I mentioned earlier, Section 11 of the PSA is that subsidiary legislation that's giving effect to the non-discrimination clause and the equality clause in the Constitution. 11.1 says, in the making of appointments and the filling of posts in the public service, due regard shall be had to equality and the other democratic values and principles enshrined in the Constitution. So itself says that if you want, when you're determining who should be appointed, you have to take into account the constitutional value of equality, which means that what it does is it imports Section 9 of the Constitution in. So if you want to find out what are those obligations, you can look at the Constitution itself. But it's this legislation which provides that power. So it's not a direct reliance on Section 9 of the Constitution, it's indirect reliance because it's incorporated. Now, the other democratic values imply non-racialism. That's in Section 1 of the Constitution. It also implies equality before the law. So those are the sections that can be relied upon to make the claim that the policy itself is unlawful and that it breaches Section 11.1 of the PSA, and by implication is unconstitutional because the legislation makes reference to the Constitution and the Equality Clause. So there's no need to have run an Equality Court case using PEPUDA. This legislation is sufficient on that grounds and meets the subsidiarity requirement.
Okay, thank you.
Thank you very much, This is now 25 past 12, and we're going to adjourn and we'll resume at 1:30. Court adjourned.
Can we get a counsel on this dangerous? Can we come down here? Yeah, dangerous. Nothing.
Careful,
there.
there's lawyers around.
Nothing. Even my gown. In the red bag? Really? What's that? In the book? Sunglasses. That is something. I realize that. I'm happy to talk about pizzas. Do you like one that banana pizza? That's right. Yeah, banana pizza. Those are better. I like pizza with anything, including banana. Plus, SABC bonds there as well. Yes. More sense
So we couldn't start at 12:30. I had some engagements. The applicant may proceed, Mr. Morrison.
Please the court. I would be with the court's leave asking my learned friends, Messrs. Sulukazana and Ayer, to follow me as we take the 2 or 3 hours allocated.
The 2 hours.
2 hours, as the court pleases. The outline of our address commences with our identification of the parties that we represent, being the African National Congress, the Cadre Deployment Committee, and being the Deputy President of the African National Congress as the head of the Cadre Deployment Committee. So we've got 3 respondents that we represent, and that will become relevant towards the end of the matter. We acknowledge the contribution to be made by the President's team for the Minister and the team for the Minister, and recognize that they have particular roles and they are going to address arguments which are distinct from ours. We endorse and support their arguments, but we do not intend to repeat them. The chapter headings for my address, which I will introduce, and I'll also introduce the chapter headings for my learned friends' addresses, will be the following: freedom of speech and the interpretation of sections 16 and 18 of the Constitution, the dispute of fact, declaratory orders and discretion, the role of the amicus, and costs. My learned friend Mr. Sulukazana's address will comprise 5 chapters: the difference between political party and state, the failure to show any contravention of constitutional rights, the proper approach to litigation, no breach of the Public Service Act, and the appointments referred to in the papers cannot be challenged at this stage. Mr. Ayaya's address will comprise 3 chapters: the legitimate limits to political activity, the role of politics in staffing decisions, and separation of powers or jurisdiction. And then, if necessary, I will close the argument after my two learned friends have addressed you, but I don't anticipate that that will be required. I'd like to start then with some clarification of certain concepts that surface in the matter. And they are straightforward, but they need articulation because there has been some confusion. The first is, what is a cadre? The dictionary definition is a loyal person. To deploy is to use. So cadre deployment, on its simple English, is to use loyal people. Loyalty itself has ambiguity. There can be loyalty to the ideals of the ANC when you're not a member of the ANC, which would have the important implication that only members of the ANC can be disciplined by it. And then there is loyalty to the interests of the ANC as a party, which is a different concept. Loyalty to the ideals versus loyalty to the party interests, which may go to its political aspirations. The ANC expects government to apply its own criteria, not ANC criteria, save where they overlap. The ANC recognizes that when one is appointed to government, the first duty is to government. That conflicts of duties, and it's a phrase we'll use more than once, there are conflicts of duties as opposed to conflicts of interests. Conflicts of duties must be resolved in favor of government. That is a necessary incidence of employment. An employee is obliged to devote their full time and attention to the employer's interests and government's interests, where the government is the employer, to serve all people equally, and they are not identical to party interests. Government employees must leave at the door, when they walk into the government office, their party hats. The bright line which exists in law between party and state must also exist in the minds of the government employees and appointees. A fiduciary duty exists to the employer, be it a company or a commission, state-owned entity. Our learned friend said that we seek to protect a constitution-free zone, seek to argue for a constitution-free zone. We would invert that and submit that the space that the party enjoys here is the most protected space in our Constitution. It is in the Bill of Rights. And in the Bill of Rights, we find ourselves in an enclave of protection under Section 16, which reads, as Justice Mochapela well knows, freedom of expression. Everyone has the right to freedom of expression, which includes A, freedom of the press and other media. B, freedom to receive or impart information or ideas. C, freedom of artistic creativity. And D, academic freedom and freedom of scientific research. The right in subsection 1, which I've just read out, does not extend to A, propaganda for war, B, incitement of imminent violence, C, advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. We pause there for a moment. The structure is of the right. Man is born free, save to the extent that they are constrained by law. The law recognizes the freedom of the individual to say what they will. The law identifies certain aspects of that freedom which are particularly worth mentioning, such as freedom of the media, creative freedom, academic freedom. And it says the right does not extend to these other categories of speech. So to an extent what it does is it says there is a category of speech that we take account of, and the rest is completely free. That's important when we get to some American decisions that I will use to illustrate the principle that the content of the speech is entirely irrelevant unless it falls into one of those sections that is prohibited. The courts do not look to the content of the speech unless it can be shown that it transgresses subsection 2, propaganda for war, incitement of imminent violence, advocacy of hatred based on race, ethnicity, gender, religion, and constitutes incitement to cause harm. There are statutes which also limit freedom of speech, such as the one used in the UDM case, where the DA sent out a SMS saying, see how the ANC has stolen your money. And there's a prohibition in that electoral act that says you can't make false statements about other parties. And the question that was debated in the court was that an inhibition of freedom of speech or not? Does the section stand or not? So, using the principle people are free but for the extent to which they are constrained by law, as articulated in the structure of this section, unless the DA can show that this is one of the prohibited forms of speech, the court can have no regard to the content of the speech. It is not one of the prohibited forms of speech, and the ANC can say what it likes about who it would like in office. And any political party can say who it would like in political office. And what the DA is trying to do is to limit the rights of political parties, including itself, to say who they would like in the public service, who they would like in office, how they would like to see the country run. Because in their version of the case and on their interpretation of the law, one can come to court and say, I don't like what they're saying, stop them, because I think it contravenes a provision of the Constitution because it undermines democracy in some amorphous way. It doesn't. It's not one of the prohibited categories of speech, and it is sacrosanct. Let me tell you then about the American cases of Shachtman and Bosley. Shachtman is in our heads of argument. It's an annexure to the heads of argument, and it's at 006-104. Mr. Shachtman was, well, I beg your pardon, 006-194. Mr. Shachtman was a candidate for political office in Chicago, but he was running as an independent in the 1970s. And what he wanted to do was to stop the Democratic Party and the Republican Party from using city funds in the city of Chicago to pay for party workers. They were paying party workers to distribute pamphlets, arrange party picnics, and raise money for the Democratic Party and the Republican Party. And there was a system of patronage of remarkable corruption. And Mr. Shachtman said, no, please don't do that. I'd like the court to stop them. And one of the grounds on which he sought to get the American court to stop the patronage of these parties, to use state funds to support the party, was the freedom of expression right. And this is what the court said at 006-194 under the subheading, the candidate's interest in political expressions. Freedom from government-imposed restrictions on the content of belief or expression is the central promise of free speech as guaranteed by the First Amendment. That's the free speech amendment to the American Constitution. Above all else, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. This is especially true where the political belief and expression are involved. It can hardly be doubted that the constitutional guarantee of free speech has its fullest and most urgent application precisely to the conduct of campaigns for political office. Reading on in our own Constitution, we have the right of assembly, demonstration, picket, and petition. Everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and present petitions. Freedom of association. Everyone has the right to freedom of association. Political rights, echoing Shachtman. Every citizen is free to make political choices, which include the right, A, to form a political party, B, to participate in the activities of or recruit members for a political party, and C, to campaign for a political party or cause. Every citizen has the right to free, fair and regular elections for any legislative body established in terms of the Constitution. Every adult citizen has the right to vote in elections for any legislative body established in terms of the Constitution, and to do so in secret. And B, to stand for public office and, if elected, to hold office. Neither the DA nor the amicus invoke Section 36 to try to limit the ANC's rights to freedom of expression. Nor can they point to a provision in the Constitution that limits the right to express oneself as the ANC does here. We emphasize the right of the electorate to make political choices. The DA seeks to eliminate one of these choices, to choose a party which applies a cadre deployment policy. To succeed, the DA has to bring the cadre development policy within the categories of speech which are not protected. If it doesn't do so, it must fail. Let me then go on to a description of Mosley. It's a particularly interesting case in America, where the police department of Chicago, cited in the Shackman decision, had to deal with the following scenario. Mr. Mosley was a federal postal employee who, for 7 months prior to the enactment of the ordinance, had frequently picketed Jones Commercial High School in Chicago. During school hours, and usually by himself, Mr. Mosley would walk the public sidewalk adjoining the school carrying a sign that read, "Jones High School practices black discrimination. Jones High School has a black quota." His lonely crusade was always peaceful, orderly and quiet, and was conceded to be so by the city of Chicago. He brought a suit saying that the statute which was then passed to prevent picketing near schools on all but labor issues punished activity protected by his rights of free speech under the First Amendment. The court said, "We hold that the ordinance is unconstitutional because it makes an impermissible distinction between labor picketing and other peaceful picketing." It permitted labor picketing, it didn't permit any other form of picketing. It required people picketing near schools to be at least 150 feet away from the school, which effectively neutralized Mr. Mosley's right to protest on the subject that he was protesting on. The central problem, said the court, with Chicago's ordinance is that it describes permissible picketing in terms of its subject matter. Peaceful picketing on the subject of schools' labor management dispute is permitted, but all other peaceful picketing is prohibited. The operative distinction is the message on a picket sign. But above all else, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. To permit the continued building of our politics and culture, and to assure self-fulfillment for each individual, our people are guaranteed the right to express any thought, free from government censorship. The essence of this forbidden censorship is content control. Any restriction on expressive activity because of its content would completely undercut the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Necessarily then under the Equal Protection Clause, and the court goes on to deal with equal protection as well. But the fault in the DA's case is that they think that they can censor what a party can say. And that's exactly what freedom of speech prohibits. And they are endeavoring to assert that we are arguing for a constitution-free zone, whereas in fact, what our team is arguing for is the protection of the Constitution, of the fundamental right to freedom of expression. Even if we assume, and this is the next tier of my argument, even if we assume that the content of the policy of the party can be looked at, and the first tier is that it can't be, unless it can be shown to fall into the 16.2 categories. There is still a fatal flaw in the DA's and the amicus's argument that a policy which aims at an unconstitutional goal must be declared unconstitutional. The flaw is illustrated with a simple illustration. The Lordship has already raised it. Capital punishment. A party campaigns as a single issue party, bring back the death penalty. On the DA's argument, that would be impermissible. Couldn't be done because it's unconstitutional. What does my learned friend's head say? That the ANC's policy of cadre deployment is unconstitutional just because it exists. Well, what he doesn't answer is why are there provisions in the Constitution for amendments to the Constitution? Section 74 of the Constitution says this is how an amendment to the Constitution is achieved. One achieves a 66% majority in both houses sitting together. And the UDM decision, UDM versus ANC, says once you've been through that process, that which was unconstitutional can be made constitutional. Therefore, by necessary implication, unconstitutional ideas can and must be flighted. So if the policy is unconstitutional in its goal, it's nonetheless protected. Because logically, one must be able to move for amendments to the Constitution with unconstitutional ideas until they become constitutionally adopted, in which case they are now constitutional, as the UDM decision says. So for a policy to be unconstitutional, unless it falls into the 16.2 category, is nonsensical. An unconstitutional policy. We know there are parties that are campaigning for other changes to the Constitution. It is their right to do so. Whether they can achieve that is another question. We point out that the usual route to freedom of speech decisions is when a law is passed which infringes a person's freedom of speech. They go to court as per Mosley to challenge the law, or in the ANC versus the DA, when the DA sent out its SMS saying that the ANC had stolen taxpayers' money and the provision of the Electoral Act was invoked, that was brought into play. Here, there is no text of any statute which says you can't have a cadre deployment policy. The DA wants the court to interpret the Constitution to come to that conclusion, to say, in effect, the Constitution means you can't have a cadre deployment policy. Applying principles of interpretation per Coral Lagoon and other cases relating to interpretation of statutes. There is no explicit text to that effect. Then we look to context and purpose. Both support the continued existence of the cadre deployment. Context, the ANC has had the policy since 1985, since it was banned. And it's been re-elected with that policy ever since. The question we pose to the DA is, when did it become unconstitutional? We've had the same constitution since 1996. Did the DA suddenly realize that it became unconstitutional after Zonda? Or has it always been constitutional? And is the DA, contrary to what my learned friend said earlier, using corruption as equivalent to cadre deployment, conflating the two, and arguing that cadre deployment shouldn't be used because it's associated with corruption? Well, let my learned friend tell the court about the association between capitalism and corruption. Let my learned friend tell the court about the association between a multiplicity of other government organs and corruption. About the possibilities that those entities are corrupt not because of cadre deployment, but because of human greed, venality, failure to enforce laws, and a multiplicity of other causes. And that exposes the weakness in the argument. Because the argument, as my learned friend Mr. Oppenheimer tried to advance, is we have load shedding because of cadre deployment. We have every possible ill in society because of cadre deployment. But we've had cadre deployment since 1985, when this party was banned, as the ANC would, as the DA would now have our policy banned. From the time that we came into power as the ANC, 1994, 96, the new constitution, this policy has been there, and it has served a very important function, as my learned friend concedes. How has the policy changed? What has changed is the way in which it's been used by illegal agencies. And when illegal agencies use state institutions, it's not the institution or the policy that one attacks, it is the illegal functions. When policy becomes law, this was your question, Justice Mojapela, when policy becomes law, when policy is implemented, is that not when the courts can intervene? And that clearly must be so. Implementation, as my learned friend Mr. Salakazana articulates in his argument, is a very different thing from holding a policy. When government starts to implement a policy, then the courts can intervene, then the courts can exercise an attack on the manner in which the policy is used to affect the rights of citizens. But for so long as it is an expression of free speech in the hands and mouth of a political party, it is a vital protection that the courts offers through our Constitution to a healthy and recovering democratic process. And that, if I may deviate momentarily, is one of the reasons why I mentioned Shackman. Because Shackman ends with that entire system of patronage that existed in Chicago, but under both the Republicans and the Democrats, being eliminated by that litigation. The truth is, one can permit things to happen, one can permit statements to be made and protect freedom of speech without promoting corruption. One can eliminate corruption whilst protecting freedom of speech. And that disjunct is not appreciated by our learned friends. Our learned friends seem to think that unless one constrains the cadre deployment policy, corruption will continue. That link is not made on the evidence, it's not made in any of the cases, and can't be proved other than on individual cases where the facts have to be very carefully considered. And I will come to the decision of Walele, which is related in our heads, in which there is a debate about the extent to which a person making a government decision can take account of other people's views. And what Walele makes very clear is that if you're a decision maker, you can take account of other people's views. We're not dealing with judges who can't be influenced at all. We're dealing with ministers who are entitled to consult. We're dealing with politicians required to appoint senior people in circumstances where the country is in transformation, where the information available about the candidates is not necessarily as it might have been in a society where you have thousands of years of stability, where you can look at what somebody got when they were at Oxford, you can look at what somebody got when they were at Cambridge in their engineering degree. Here you're dealing with people who were in the struggle. They were underground, they were detained, they were subject to an inferior education system. Why not ask the ANC, is this person okay for this position in this country with our history? The DA would have it that we live in some utopia where everybody has an educational pedigree and none of the horrors of our past seem to enter into their thinking. The choices that are made about the people who will serve our people have to be made at a human level with recognition of our history. They cannot be made in the utopian meritocracy that the DA seems to think we live in. I turn then to the question of motion proceedings. If the court rejects argument 1 and considers the content of the cadre deployment policy and goes into it, then there are in our submission 2 disputes of fact. 1 is the policy recommendation or appointment, and 2 were the Gama, Malefi, Montana, Singh appointments applications of cadre deployment or of the then president. 2A, recommendation versus appointment, which if the court accepts the Chapter 1 argument would make no difference. We ask the court to look at paragraph 26 of Mr. Steenhuisen's affidavit, who says that Mr. Montashe and President Ramaphosa were lying to the Zondo Commission. Mr. Steenhuisen says, at the outset, however, it is important to highlight that the President and Minister Mantashe repeatedly emphasized at the Commission that the Cadre Deployment Committee merely recommends candidates and that it does not dictate to ministers and other officials who to appoint. This was done in a bid to sanitize the policy and create the impression that it is not at odds with the Constitution. Paragraph 27, Mr. Steenhuisen. It is now clear that this evidence was false and misleading. The minutes of the Cadre Deployment Committee between 11 May 2018 and 17 May 2021 demonstrate that the Cadre Deployment Committee does not merely recommend, it appoints. It's an extraordinary thing to see a person opening an affidavit with a credibility suggestion. One would immediately assume that motion proceedings are inappropriate to deal with questions of credibility, as we all know they are. But the complexity of the problem is compounded by the fact that the evidence was in a commission. Commissions don't have conventional cross-examination. Commissions don't have conventional argument. So my learned friend relies on certain passages of the Zondo Commission, but they weren't argued, they weren't cross-examined, and in particular on this issue of credibility, cross-examination and the obligation to put to the witness that you intend to suggest that they are lying is a critical foundation of all of our trial procedure, not observed in commission hearings. No complaints about how the commission was run, no criticism of the evidence leaders in the commission. It's just in the nature of commissions that one doesn't get to make credibility findings in the way that they have to be made in order to be sustainable in a court of law. As was said in SAFU, the institution of cross-examination not only constitutes a right, it also imposes certain obligations, and as a general rule it is essential when it is intended to suggest that a witness is not speaking the truth on a particular point to direct the witness's attention to the fact by questions put in cross-examination showing that the imputation is intended to be made and to afford the witness an opportunity while still in the witness box of giving any explanation open to the witness of defending his or her character. That wasn't done for President Ramaphosa. It wasn't done for Mr. Mantashe. What Mr. Steenhuisen does is he says this is what they testified on. They said it was recommendation. But if you look at the minutes, which weren't put to them, they lie. That's impermissible. One cannot start motion proceedings on the basis that you can contend that the other side is lying unless you can establish it within the parameters of how it's done within the law. At paragraph 70 of the SAFU decision, counsel for the Mr. Lake says, at the same time I want to make use of this opportunity to state quite clearly that we have been accused of having called the President a liar. We have not done that. We have said certainly that his evidence is not to be accepted and that we still submit. That was President Mandela. Such a submission could never have been made if the respondent's case had been that the President had engaged in a dishonest charade. The judge correctly held that the above statement did not amount to a formal admission, but this in no way detracts from the fact that this passage is a description by respondent's leading counsel himself of what meaning should be attached to any imputation which up to that stage might have been made against the President. It is also the only reasonable explanation for the failure to dispute the President's evidence relating to his meeting with Professor Katz and the fact that he acted on the advice given to him. This could only have been disputed by a direct challenge to his integrity and dishonesty, not done to President Ramaphosa, not done to Mr. Mantashe. In the light hereof, there is simply no factual basis for the conclusion reached by the judge that the President had prior warning that his honesty and integrity were going to be impugned. It is simply not open to Mr. Steenhuisen, under the circumstances, to contend that the President and Mr. Mantashe were lying. Advocate Freund has a few passages where he dealt with Mr. Mantashe's evidence as follows. He says, "I want to put it to you that it is not correct, as you have said, that any party tries to place people on those structures, loyal to and accountable to them, is under a duty, as it were, to report to them, the party rather than the organization in which they are employed." You disagree with that, do you? So Mr. Freund wasn't cowed by Mr. Mantashe. He went into the question of what Mr. Mantashe's evidence amounted to. And he goes on, "When those deployment committees are making their deployment decisions, I want to put to you that it seems logical to assume that the people they are seeking to deploy are indeed their cadres. Not necessarily cadres who lack skill or competence or training, but it is in the nature of the exercise that you are talking about, the deployment of your cadres, are you not?" That was the extent to which there was confrontation, challenging on what was being debated. But the minutes probably became available later. As I say, no criticism of the evidence leaders in the commission, but they weren't put to these witnesses on the passages within the affidavit, and it cannot be sustained to suggest that either Mr. Mantashe or President Ramaphosa cannot be believed. On the contrary, Plascon Evans would hold that they must be believed. Let us then turn to the minutes themselves. Clearly, the members of the deployment committee wanted to dictate. They wanted powers to tell the government exactly what the government should do. That's very human. But did they achieve their objectives? Did they dictate? Only the ministers in question can confirm or deny this. When they were told by the cadre deployment committee who to appoint, did they take the lead for Mr. Mantashe and President Ramaphosa? And no matter how strident the committee's views, they were only a consultative body, a recommendation body, a body who, by reason of the ANC's collective decision-making processes, had to be consulted. At the end of the day, the decision was still the ministers. Who do you give the benefit of the doubt to on motion? The respondents. Unless it can be shown that the ministers did execute the decisions, that the dictation did actually happen, that it did result in particular people being appointed. We don't know of one individual mentioned in all of those minutes who gets the appointment and whose appointment was necessarily flawed by reason of the fact that there was a contribution from the ANC cadre deployment committee. If we use the case that my learned friend loves to refer to, Mlokoti, what happened in Mlokoti? There were two candidates for a position, I think, of municipal manager in the Amatori Municipal Council, cited in my learned friend's heads. The local ANC, which is not cited as a party, says we'd like the number 2 candidate, a gentleman with the less established credentials, at an academic and competence level on the scorecard. The mayor and the city council of Amatoli appoint the number 2 candidate. Comes before Pickering J, exposed that the reason why this person was appointed was because of the ANC's contribution. The appointment is reversed. It's overturned on review, and the number 1 candidate wins. That was Mr. Mlokoti. But take the opposite. Assume there was a suggestion from the ANC that Mr. Zenzele, who was the number 1 candidate, should actually have been the one to get the job. Is the fact that the ANC has made a contribution to that decision sufficient to overturn that appointment? Or is it but one of the facts that must be taken into account? A learned friend would suggest that the minute a subject matter of an appointment comes up in a meeting, the minister or the individual, the politician concerned, must recuse themselves. In our submission, that's not appropriate. It's not in any way realistic.
Yeah, before you amplify that aspect, I don't know if you're still going to deal with this issue in your argument. They said the fact that in the ANC policy, there is sanction if you don't follow their direction. That amounts to them taking everything what the deployment committee is saying. What are you saying on that point?
It's been very carefully articulated in the affidavit. My learned friend read it out, and it's a particularly delicate point. And it comes down to the two hats problem. We are, as individuals, not monodimensional. We have duties to our churches, to our sports teams, to our families, multiple roles that we play. When you're a member of the ANC and you're appointed to government, your first duty, as we submitted earlier, is to government. However, if you are given a recommendation as a member of the ANC as to who the ANC thinks should be in the position, you go into government, you decide on someone else, you exercise your independence of choice, you conduct yourself in a manner that is precisely as you should, committed to the principles of good governance, not the interests of the party. The party can say, as our affidavit says, we'd like an explanation. Why did you do that? And if the explanation is sound, you can't be disciplined. And if it's not sound, then you might be disciplined within the party, but you can't be disciplined within your workplace. The workplace is sacrosanct. The employment contract is respected by the ANC. And the discipline is imposed only insofar as the membership of the ANC is concerned. It may bring about an element of persuasion. It may bring about an element of needing to explain, but that's party discipline. We need to explain ourselves to each other. If we make bad decisions and we come home to our spouses or our families, the fact that we explain ourselves to them doesn't mean that we didn't act independently. What the ANC says very clearly in its affidavits is when a person is employed by government, we expect that person to do their job for government. But when they are a member of the ANC and they appear to have done something which conflicts with our principles, we'll ask them to explain. And we see no contradiction in that. They can live together. It's a system of checks and balances. It is complex. It's not a straightforward all right or all wrong, winner takes all approach. It's a question of degree, and that's why, as my learned friend Mr. Silakazana will argue, these are issues that cannot be decided in a broad sweeping declarator. They have to be decided on a fact-by-fact case basis, on a case-by-case basis, precisely because one might come to the conclusion that that was dictation in that situation if you posited a particular degree of influence, but you might also come to the conclusion that it was a permissible degree of advice without amounting to dictation. We can't answer that question in this argument because we're confronted with a sweeping declarator that is so vague with such potential ramifications that it's actually impossible to answer these questions other than to descend into a range of hypotheticals which one ought not to engage in. What courts of law should be doing is deciding issues of rights on particular facts, and Walele is particularly clear on that. That's Justice O'Regan, and she says it as follows at paragraph 112 of the Walele decision, Walele versus City of Cape Town and others, 2008, 6 SA 129. The applicant's next argument was that Mr. Griffiths was the decision maker. Mr. Griffiths failed to exercise an independent discretion when approving building plans. This argument is closely allied to the argument he makes that Mr. Griffiths acted under unlawful dictation. I consider both arguments together, says the then acting Deputy Chief Justice O'Regan. The evidence on the record is that the plans and the building development management documents containing the approval of the separate municipal departments and Mr. Moyer's recommendation were forwarded to Mr. Griffiths, and that Mr. Griffiths then approved the plans. The applicant relied on the following dictum of Nkobo J in a minority judgment in New Clicks. The minister is required to make regulations based on the recommendations of the pricing committee. The minister does not merely rubber stamp the recommendations of the pricing committee. She is required to apply her mind to the recommendation and make a decision whether or not to accept such recommendation. She cannot therefore accept the fees proposed by the pricing committee simply because they have been proposed by the pricing committee. She must satisfy herself that the fees proposed by the pricing committee are appropriate. She can only do this if she is furnished with an explanation as to how the fees were arrived at. Without such information, the Minister cannot properly evaluate the appropriateness or otherwise of the fees proposed by the Pricing Committee. That case, says O'Regan J., concerned the Minister's powers to make regulations to regulate the price of medicines. What needs to be understood is that in determining whether a decision maker in any particular case has failed to exercise an independent discretion or acted under unlawful dictation, the context of the power in question and the manner of its exercise are all important. It must be done on the facts. It can't be done in the air. It is impossible to lay down a general rule as to what will be required. That's the death knell for this entire application. It is impossible to lay down a general rule. What the DA is asking for is a general rule. Thus, continues O'Regan J., to decide whether an official has failed to exercise an independent discretion or acted under unlawful dictation will require an understanding of the context of the legislation in question. The importance of context was recognized by Scott J.A. in Minister of Environmental Affairs and Tourism and Another versus Cinematic 14 Pty Limited. A functionary in whom a discretionary power is vested must himself exercise that power in the absence of the right to delegate. But it does not follow that a functionary such as the DDG in the present case would have to read every word of every application and may not rely on the assistance of others. The Minister can rely on the views of the cadre deployment committee. Indeed, given the circumstances, Parliament could hardly have intended otherwise. What the functionary may not do, of course, is adopt the role of a rubber stamp and so rely on the advice of others, that it cannot be said that it was he who exercised the power. That's the problem with dictation. If in making a decision he were simply to rely on the advice of another without knowing the grounds on which that advice was given, the decision would clearly not be his. But by the same token, merely because he was not acquainted with every fact on which the advice was based would not mean that he would have failed properly to exercise his discretion. Whether, therefore, there has been an abdication of the discretionary power vested in the functionary is ultimately a question that must be decided on the facts of each case. How much more does one need to say about the attempt by the DA to get this broad rule? We submit that on the application of the Plascon-Evans test, confined to the finding affidavit and the annexures properly referred to, as per the Swissborough decision, complemented in this case due to the evidence of the Zondo Commission, inadmissible but for the passages in the founding affidavit properly cited, and the impermissible portions of the replying affidavit, and the principles of Small versus Smith and Safu, which I've referred to, the court has to find the matter, has to find on the facts of the matter and the Plascon-Evans rule that the policy is one of recommendation, as President Ramaphosa and as Mr. Mantashe said. Then I turn to the subject, the third of my 5 chapters, declaratory orders. The dangers associated with this order are enormous. We have suggested that if the order were granted in its terms, anybody disgruntled in the public service with the appointment of someone where the ANC cadre deployment policy may have played a role would be equipped with this order to say, this has been found unconstitutional. You were appointed with input from the ANC cadre deployment policy. You should be dismissed. I'm reviewing all your appointments and I'm reviewing all the decisions that you took as an administrator because you were appointed consequent upon an unconstitutional appointment because the ANC cadre deployment played a role. That's an extraordinarily dangerous situation to create, and I'm surprised that my learned friends for the DA and the amicus don't see it. But fortunately, as my learned friend for the DA correctly points out, this is a question of law, and the law does protect one in these circumstances because declaratives can't be granted in respect of past events. And that's the authority for that is Naptosa and others versus Minister of Education, Western Cape, and others. 2001 2 SA 112. Relying on the old Supreme Court Act, section 19, which has its correspondent in section 21(1)(c) of the Superior Courts Act, has almost identical wording. Conradi J, with Charlie J concurring, says, this section gives the High Court jurisdiction in its discretion and at the instance of any interested person to inquire into and determine any existing, future or contingent right, notwithstanding that such person cannot claim any relief consequential upon the determination. A court having at the first stage of the inquiry decided that the claimant is a person interested in an existing, future or contingent right or obligation, would at the second stage inquire whether or not the dispute is a proper one for the exercise of its discretionary power. As to this, it must be borne in mind that though it may be competent for a court to make a declaratory order in any particular case, the grant thereof is dependent on a judicial discretion by the court and with due regard to the circumstances of the matter before it. What the discretion entails is explained by Williamson J., and the court will be familiar with those principles. I don't intend to read them. The fundamental point here is that the declaratory order need have no claim for specific relief attached to it, but it would not ordinarily be appropriate where one is dealing with events which occurred in the past. Such events, if they gave rise to a cause of action, would entitle the litigant to an appropriate remedy. Goes to your Lordship's question from my learned friend earlier in the day. If there are alternative remedies, there are appropriate remedies, why would I give you a declarator? The answer is one shouldn't. There are these remedies. If they want to set aside the Gama appointment and various other features of the Zondo Commission, evidence that they are concerned about, as we all are, there are remedies in relation to those. And the granting this declarator is not the remedy for those actions. We emphasize that individual remedies should be used. I then turn to the question of the amicus. And we have the description of the function of an amicus as being to be a friend of the court, to make cogent and helpful submissions. In our submission, our learned friend, Mr. Oppenheimer, did not achieve that objective. He did not confine himself to those bounds. He took up court time reading from his heads, which the court twice asked him not to do, and he made some unsubstantiated allegations which are contrary in our submission to the content of the minutes and do not take account of the historical realities which the court is entitled to take account of, which we've cited in the McGregor article attached to our heads of argument.
So to interrupt you, Mr. Morrison, the appointment of the amicus in this matter, was it argued in court or was it by agreement?
It was by agreement. But one agrees on the basis that one assumes that one's learned friend is going to confine oneself to himself to the role of an amicus. And regrettably, we were given no new law. We were given a tirade of political content which made no contribution in our submission to the decision of the matter. And the court retains a discretion despite the agreement. My learned friend Mr. Silikazana points out. So turning then very briefly to a summary of the matter, the cases we've cited and the costs argument. We used Hart versus Pinetown to say that one could look at the case of the DA alone and see that it was defective on its own terms without even looking at the answering affidavit. We used Swissborough to say that the DA must be confined to the passages in its affidavit that it refers to specifically, and it can't go into the whole of the Zondo Commission to support its arguments. We used Esau to argue that they can't make out their case in reply. We wrote to the DA after they launched their founding papers, and they had made the point that there were still volumes of Zondo to be delivered. We said, there's still volumes of the Zondo report to be delivered. Would you indicate whether you intend to supplement or not before we file our answer? They wrote back, they said, we're not supplementing. They closed the door on themselves at the founding affidavit stage. Their replying affidavit is full of additional references to the later Zondo reports, and we've asked the court to disregard those. In Umlokoti, we have been through that, and Walele, under what circumstances does dictation arise, and it's very fact dependent. The McGregor passage that I indicated to Justice Bam would make reference to is at 006-187, milady. And what the learned author says, that judicial notice can be taken of the history of the country, and that it is unnecessary and wasteful to prove historical discrimination, for this exacerbates conflict and division. Another valid argument is that by proving disadvantage, it may be counterproductive to the present transformation of society. And yet, the amicus comes and tries to prove that they are being disadvantaged. In our submission, a startling argument that should be rejected. The learned friend makes reference to people not being judged on the amount of melanin in their skins. We've complained before about the lack of historical insight in the manner in which this case has been presented. If our learned friends of the DA and the amicus think that this is a matter about melanin, they are gravely mistaken, and they fail to take account of the history of the country and the circumstances under which this policy came to exist and the important role that it has played. If it is a policy that has seen its time out, the electorate will have something to say about that in time. But it is under no circumstances open to the DA or the amicus to suggest that it is a policy that can't be advanced in contravention of the freedom of speech, which was so hard won. Our final submission in relation to costs is we represent 3 respondents. Each of them would be entitled to 2 counsel each. The first is the party itself, the second is the committee, and the third is the deputy president, or vice versa. Each would be entitled to 2 counsel. We've only got 5. There are thousands of pages of documentation in Zondo. Our learned friend used all of them in terms of incorporation by reference. In our submission, it would be entirely appropriate to grant costs and not to use the bio-watch principle under these circumstances. The case is an abuse, and it is a hopeless case that has grave dangers for society if granted in the vague and inappropriate form of a declarator.
You also see costs against the amicus.
We want costs against the amicus as well. They've made common cause. We want them to bear the costs jointly and severally. And in our submission, that would be appropriate given the manner in which the amicus's case was presented. And in summation, we would submit that what is needed in our society is a system of checks and balances, not a violation of the right to freedom of political expression, which characterized our law for so long and so humiliatingly for almost the whole of the 20th century. And we cannot go back to the days of banning orders for political voices because we do not agree with them. And a costs order would convey that message most efficiently in our submission. I now hand over to my learned friend, Mr. Salakazan.
Yes, Mr. Salakazan.
Good afternoon, Justices. In summary, I will make submissions that the case presented on behalf of the DA is ill-founded, it is mistaken, and an opportunistic political act. It is divorced from the facts and would lead to an absurd outcome. I propose to structure my address in 5 parts. In the first instance, I will make submissions with the support of authorities of the Constitutional Court that there is a difference between a political party and the state, public administration, or the government, and that the fact that a particular political party is a majority or so-called ruling party does not render any actions or policies of that party those of the state. Secondly, I will, going through the founding affidavit, demonstrate that the sections upon which the DA relies to found its constitutional invalidity claims do not apply because the ANC is a political party, and all the provisions refer to state action, they refer to actions or create obligations for operators in public administration. And then thirdly, I will address the relief they seek in prayer 3, that is to say that there is a breach of the Public Service Act. I will, during my address, show that the sections to which they refer, which is Section 9, Section 10, and 11, are not breached at all. And again, as is consistent, I will show that the obligations are on state actors and not political parties. And so it is not possible for the ANC as a voluntary private association to breach those obligations. And then my fourth topic will be to show that, and it's a direct answer to the question of what is prohibited. Is it an attempt to influence or the taking into account of the influence and the weight that is placed on that influence? I will refer to a case of Glenister versus the President of the Republic of South Africa to show that it is acceptable for political parties to seek to have their way. The obligation ultimately lies with the constitutional agent, as it were, and in certain instances it would be the minister. And so what has to be considered is not an attempt by a private party to influence, but what weight was placed on that influence and whether or not that influence was the only consideration and whether or not it was an irrelevant consideration in the circumstances. And then finally, I will, with reference to the 5 appointments that the DA canvasses or discusses in its founding affidavit, demonstrate that there has been no attempt to show that the 5 individuals were appointed as a result of direction or dictate from the deployment committee, and there's been no attempt to show that they were ill-qualified, non-suited, and therefore only appointed to perform corruption. And there is no relief sought here to review and set aside those particular appointments. If I may then start with the first point. The DA has a section in its founding affidavit that is entitled The Legal Basis for the Relief Sought, and that is at page or case line reference 002-47. The particular references or sections in the Constitution they refer to,
Excuse me, it says
002-47.
Thank you.
That's where the heading legal basis for the relief starts. And then over the page at dash 48, the court will see that they refer specifically to section 7 of the Constitution at paragraph 106 of the founding affidavit. And there they say, the ANC's cadre deployment policy is at odds with section 7 of the Constitution. It undermines the Bill of Rights. It erodes democratic values of human dignity, equality, and freedom, and it weakens the ability of the state to protect and promote the rights in the Bill of Rights. Mr. Morrison had already spoken about the tools of interpretation, and consistent with that, I wish to ask the court to turn up the particular wording of section 7. And I understand that extracts of the Constitution have been uploaded, and this particular section is at case lines 007-4. As the court has seen, the DA primarily relies on section 7 in founding the obligation that it claims the existence of the deployment policy and the existence of the deployment committee breaches. Section 2 reads as follows: the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. we submit that the first two words of that provision make it clear that it is the state that has that obligation. And that is important because the Constitutional Court has recently, in the judgment of Public Protector versus the President of South Africa, and it's at case lines 007-315, the particular paragraphs are paragraphs 103 to paragraph 107, and those are at case lines 007-319 to -320. And 103 is important, and I wish to read it for the court. It reads as follows. This provision empowers, and this is with reference to the powers of the Public Protector to conduct investigations into public administration or state affairs. And what's important here is that the court is defining what state affairs are and identifying what public administration is. And it says, the provision empowers the Public Protector to investigate any conduct in state affairs or in the public administration. This means the scope of the power is limited to state affairs and affairs of public administration. There can be no doubt that the CR17 campaign was engaged in the affairs of the ANC, which is a political party. The fact that it was the ruling party at the relevant time did not make it a part of the public administration. We say that that applies here too. The fact that the policy that we are dealing with today, the deployment policy, is that of the ruling party, does not make it a policy in public administration, and that will become relevant when considering the specific sections and provisions of the Constitution upon which they rely to make their case. So we say that that principle should be carried out here too when determining the issues before the court and when determining or assessing the legality and validity of the deployment policy. And so, having dealt then with Section 7.2 and having shown with support from the Public Protector judgment that because the ANC is a ruling party, it is not the state, it is not involved in state affairs and not in public administration. Section 7.2 says the state must respect. So it is unavailable to the DA in seeking to found a constitutional challenge to claim that the ANC has breached an obligation that lies at the hands of the state and not at the hands of the ANC. So their reliance or reference to this provision in our submission is mistaken, and the prayer should be dismissed. The next provision they rely on is Section 195 of the Constitution. And they start in their founding affidavit at page 002-50. The section has been included in case lines at 007-7. It is a long section, so I shan't detain the court with a full recitation of the section, but I think it's sufficient, at least I submit it's sufficient, to read the first subsection, and it reads as follows. Public administration must be governed by the democratic values and principles enshrined in the Constitution, including the following. And what it lists are principles of transparency, principles of accountability, and principles of efficient use of resources. Again, this provision speaks to the conducting of conducting of governance in public administration. It cannot be said that the ANC, in the policies it passes, has to consider the obligation set out here for public administration. The ANC is outside of the state, and it is allowed, in accordance with its rights to freedom of expression, to aspire or seek to attract voters by communicating any policy it may wish to do so, and it is only once the policy is implemented in public administration that any interested party can claim that there is a breach of Section 195. The next section in the Constitution they turn to is section 1973. The reference to that in their founding affidavit is at paragraph 118, and that is at case lines page 002-52. That section is also uploaded on case lines at 007-7. The section reads, no employee of the public service may be favored or prejudiced only because that person supports a particular political party or a cause. Starting with the text of this provision, we submit that it speaks about a relationship between an employee and an employer. In instances where a political party is agitating or motivating for the appointment of someone, that person has not become an employee, but a candidate for employment. And that is important because, again, this section governs the operation or regulation of public administration. So as a state organ, you aren't allowed to prefer or prejudice an employee because of their political affiliation. So that's the first reason we say it doesn't apply. It applies between employer and employee. The employer is the state, and the person, the prohibition is against preferring or prejudicing an employee. The deployment policy speaks to promoting or agitating or motivating for candidates to be employed. So therefore, the policy falls outside the ambit of 1973. And in the second instance, even if the court were to accept that a candidate qualifies as an employee for purposes of this section, we submit it doesn't, but assuming for a moment that it does, the important qualifier is that you cannot be prejudiced or favored only because of your political affiliation. We submit that that contemplates, or that it may be inferred or implied from the use of the word only, that political affiliation may be a factor in your appointment, but it cannot be the only consideration. And that is important because, as Mr. Morrison has said about the Mlokoti judgment upon which the DA has relied to demonstrate that some deployments in the Eastern Cape have been set aside, what the court found there was that the municipality responsible for appointing the manager completely abdicated its constitutional obligations and its statutory obligations in applying its mind to the criteria, and was guided only by the direction or the command of the regional executive committee in the Eastern Cape. And that's the point we wish to make here too, that the use of only acknowledges that there are instances when a party can approach whoever is appointing, because parties don't appoint, to seek to have people they think represent their ideals and align to their principles in public administration. So to say that it is impermissible to seek to influence it all is unfounded. And that issue has come up in the Glenister judgment I referred to earlier. The citation is 2009, Volume 1, South African Law Reports, at page 287, and it's a judgment of the Constitutional Court. I understand that an extract has been uploaded on case lines, and it is at 006-305. The particular paragraph I wish to refer to is paragraph 54 of that judgment. And again, for context, what happened here was that the cabinet had adopted or conceived of a legislation that would affect where the investigating, I think, unit of the SABC would be, whether it would be under the SABC or whether it would be independent, which is what was called the Hawks. And there was a complaint by the UDM, or Scorpions, I think. There was a complaint by the UDM that the legislation was initiated at the direction of policy decisions taken at the 2007 Polokwane conference of the ANC. And in paragraph 54, Chief Justice Langa says, the UDM argues because the decision to initiate the legislation arose as a result of the Polokwane resolution, Cabinet acted under dictation in making the decision to initiate the legislation to establish the DSO. It suggests further that the executive followed the dictates of the ruling party rather than its responsibilities in terms of the constitution. In my view, there is nothing in our multi-party democracy. There's nothing wrong in our multi-party democracy with cabinet seeking to have or give effect to policy of the ruling party. And again, this speaks to, it cannot be that there's a prohibition from seeking to achieve something. You may, going back to the text of the policy, put it in strong terms as we will direct or we will dictate. But ultimately, the power is housed in the Constitution, and it is an obligation that a minister or a public official who's been appointed under legislation has to exercise. And this is where Mr. Morrison was talking about the two hats, that once you are in government, your primary master or person obligations or people to which you are accountable are the government and the electorate and not the party. And there are instances when you may be tested, as Justice Ledwaba asked, where there is threat of discipline within the party. But the discipline occurs in the party. Your employment in public administration cannot be interfered with by the ANC, because your appointment or employment was not dependent on your membership of the ANC. So even in dire instances when you are disciplined for failing to toe the party line whilst a CEO in a state-owned entity, it doesn't mean that if you are a member, once you're dismissed or disciplined in the ANC, your employment in the state-owned entity will be affected, because that is governed by a separate regime. So the threat is not a material threat insofar as the operations of the public administration are concerned. I will turn then to speak to the alleged breaches of the PSA, that's the Public Service Act. And the references to that are at page 002-54, and it's paragraph 125 of the DA's founding affidavit. The DA claims that there is a breach of sections 9, sections 10, and sections 11 of the PSA. Once again, to avoid having the matter argued in the air, I wish to refer to the particular provisions, and I understand again that they've been uploaded, and the reference to them is case lines 007-22. Section 9 reads as follows: an executive authority may appoint any person in his or her department in accordance with this act and in such a manner and on such conditions as may be prescribed. Again, this is an obligation on an executive authority. The executive authority is defined in the PSA Act. The definition says that an executive authority includes the president, it includes cabinet, national government, office of the commission, premier's office, and provincial government. It does not include voluntary associations. So to say that there is a breach of Section 9 by the mere adoption of a policy by an entity that doesn't fall under that obligation should not be accepted. It is an obligation that is on the executive authority. So the ANC doesn't have an obligation to comply with this provision because it doesn't lie at its door. So any allegation that it has been breached, at least Section 9 has been breached, should be dismissed. I wish then to turn to Section 10. It's at the same case lines reference, 007-22. Subsection 10(1) reads, no person shall be appointed permanently, whether on probation or not, to any post on the establishment in a department unless he or she is a South African citizen, is fit and proper. there is no demonstration on the papers that the policy calls for or agitates for the appointment of people who are not citizens. That would have to be determined on the facts, whether or not the person the ANC agitates for or motivates for is not a citizen. And that also just speaks to a threat, because again, this is an obligation upon an appointer, which is the executive authority. The ANC is not an appointer. It motivates for appointments, it agitates for appointments, but the ultimate appointer is the national government and its public administration. So again, it cannot be claimed that the ANC has an obligation or any obligation under Section 10, and therefore cannot be said to have breached a provision under which no obligation arises on its part. Section 11 speaks to the appointments and filling of posts. And it says at subsection 1, in the making of appointments and the filling of posts in public service, due regard shall be had to equality and other democratic values, principles enshrined in the Constitution. And subsection 2 says, in the making of any appointment in terms of section 9 in the public service, A, all persons who applied and qualify for the appointment concerned shall be considered, and B, the evaluation of persons shall be based on training, skills, competence, knowledge, and need to redress. Again, the considerations have to be considered by the appointer. The ANC could motivate for someone who's doesn't have the skill, as is always assumed to be the case, who's corrupt, doesn't have the skill. But ultimately, when the executive authority is considering that appointment, it is that executive authority who has to comply with Section 11, and it is only when it can be established that they haven't complied with their obligations under 11 that you can challenge it. And again, we're going to the fact-by-fact basis and saying that you need to consider it specifically. And we accept that there's this notion that anyone who is preferred or motivated for, agitated for by the ANC is incompetent, is corrupt, but that is not true as a matter of fact. And of course, you will see, justices, that even the deployment policy itself does speak to properly qualified, appropriately skilled people. So in as much as the DA may wish to have a world where the ANC is only affiliated with incompetence, the policy speaks to deploying people who are qualified for those positions. So on the papers, there is no basis for any finding that as a requirement, the ANC only motivates for unskilled people. So even if it were to be accepted that the ANC's policy, or at least the deployment policy, falls under Section 11 of the PSA, it is consistent because it requires skill. It is consistent because it requires aptitude and suitability for that position. But again, our primary submission is that it doesn't fall under that because it is a policy of a voluntary association and it is not a policy of government. And then to round up my submission with relation to the facts, the DA has referred to the appointments of 5 individuals. And as we say in our answering affidavit, there is nowhere where they've shown that they were not suited for the jobs or unqualified. Because again, it's important to draw a line that the deployment policy speaks to the motivation for appointment. The DA's entire case is misguided because it is looking after the fact. It is saying you were appointed, you turned out to be corrupt. It means you are always, the ANC always knew when they deployed you that you were corrupt. The fact that a deployee turns out to not be as ethical as the ANC hoped for them to be does not, one, take away their qualification, but speaks to a faltering or abdication of their responsibilities and breach of their ethical duties. But again, that is a consideration that only arises after the employment has taken place. So it is...
Yes. Sorry to interrupt you. The founding affidavit makes reference to an extract from the State Capture Commission.
Yes, ma'am.
Where there is some interaction between the evidence leader and Mr. Moyane.
Yes, my lady.
There's something about whether he had any experience
Yes, ma'am.
of running a revenue service, etc., etc.
Yes, ma'am.
Then there is a suggestion there that he was appointed entirely without any relevant experience. I would like you to address that issue.
Certainly.
Specifically with regard to what the statement you just mentioned now, recently, before I raise my question.
Thank you, my lady. My lady, the starting point is that the DA must demonstrate that Mr. Moyane's employment was a result of the deployment policy or a result of pressure from the deployment committee. That is in the first instance. They haven't done that. Instead, they say that they make a case that it was an influence effect from the president. We know from the minutes of the deployment committee or policy and the policy itself that the president is not a member of the deployment committee. So that's the first answer to that, to say it doesn't support the case because Mr. Moyane wasn't deployed by the deployment committee on the papers before you today. And then the second answer to that is that despite his non-qualification, assuming for the sake of argument that the deployment committee did indeed recommend or insist on it, it was ultimately the appointer who had the constitutional obligation. And it is that appointer that can be accused of breaching the obligation, and the employment can then be reviewed or challenged, alleging the breach of the obligation or abdication and succumbing to the dictation of the ANC. But it is impermissible to seek to challenge the policy for its mere existence because of the outcome of the appointment of or agitation for an appointment of an unskilled candidate. So ultimately, our submissions is that because there's the separation between party and state, the ANC is allowed to have a policy under which it seeks to have as many people who are affiliated with its principles and ideologies in public administration. Whether or not they are ultimately in public administration is a matter for the operators in public administration, and that has to be considered with regard to those operators' constitutional, statutory, and policy obligations. And it is a challenge may only be brought to say you appointed Mr. Moyane, Mr. Minister X, you breached this provision of the Constitution because he was not skilled, you breached Section 11 of the PSA because he was not properly or technically qualified. So it has to be considered within its proper place. It doesn't support an attack, a direct attack at least, on the policy and on the committee.
I think I should also just remind you that the other colleagues are left with 25 minutes.
Yes, my lord. I was going to say that unless I can, I've referred to the 5 appointments, and I've said that on the facts, no case for review or challenge has been made. There's no demonstration that there were direct appointments of the deployment committee. Because the deployment committee doesn't appoint, it is ultimately the appointers who should answer to that. And with regard to the declarator under 172, we submit that on the basis or in the light of our submissions showing that there is no breach of the Constitution, the obligation that would have been triggered doesn't arise. So the court doesn't have to make a declaration that the existence of the committee or the existence of the policy is unconstitutional because there has been no showing of a breach of the Constitution. And unless I can be of further assistance, those are my submissions.
Thank you very much, Mr.
I'm indebted.
Ayayi?
As the court pleases, my lords, my lady. My lady, as stated by Mr. Morrison, my address engages 3 topics. I'm mindful of course of the fact that some of those topics have been foreshadowed in the address of my learned friends. I'm mindful of the interest of time. but if I could request that the court look favorably upon me should I exceed those time limits in a very slight manner. One of the very first of the topics which I engage is the limits to political activity under the Constitution. The second is the role of political parties in staff and appointments, and lastly, the issue of the separation of powers. Now, the Democratic Alliance has advanced that the malaise, or so it contends, evident in the public service can be traced to unconstitutional acts perpetrated by the ANC, being its involvement in staffing decisions. Now, to cut to the heart of the matter, our learned friend Mr. Katz makes two propositions. The first of those propositions are that there is a constitutional prohibition to recommendation, and secondly, what the Constitution requires is a wholly apolitical process in appointments in the public service. So, of course, the grounds upon which Mr. Katz advances that there must be a limitation of what is otherwise accepted to be generous constitutionally protected political rights, which fall under Section 19, we know the rights to political participation, Section 18, the rights to association, Section 16, which was dealt with in quite some detail by Mr. Morrison as pertaining to the right to freedom of expression, is that there is something inherent within the Constitution. There's this constitutional prohibition to recommendation. But what the bench should have noticed that at no point did Mr. Katz then go on to point out, identify, or seek to invoke that particular provision. On the contrary, the rights that the ANC asserts to be able to freely voice and impart ideas, including which candidate it believes to be suitable for particular appointments to the public service, those are, of course, guaranteed rights under Chapter 2. And they are predicated, of course, on the sections that I've already made reference to. I'd like to take the court to two decisions of the Constitutional Court. The first decision is the UDM case. It is noted in the index to the authorities bundle as item number 18. And I read from paragraph 26 of that particular judgment. It states, a multi-party democracy contemplates a political order where it is permissible for different groups to organize, promote their views through public debate, and participate in free and fair elections. The next authority, which unfortunately did not find its way onto case lines, is the oft referred to decision of Ramakatsa and others versus Makashule. I have the judgments online reference, and that is 2016 judgment online 35782. If need be, we would, during the course of tomorrow, send the reference on Twitter. Importantly, I read a paragraph 71 of the judgment, a judgment by Yacob, where he holds, in relevant parts, section 19, bracket 1, proclaims that every citizen of our country is free to make political choices, which include the right to participate in the activities of a political party. This right is conferred in unqualified terms. I'd like to stress that, unqualified terms. Consistent with the generous reading of provisions of this kind, the section says what it says and means what it says. Paragraph 72 of the judgment, this right may be limited only on authority of a law of general application, but even then only to the extent that the limitation is reasonable and justifiable in an open and democratic society. As no law of general application has been invoked to justify the limitation here, it follows that any limitation, if established by the appellants, would be unjustifiable. So, the point to be made is that far from the Constitution imposing limits on free political activity, the Constitutional Court, in no less than 2 decisions which I've referred to this court, frames these rights generously. Now, if the DA seeks to contend for a contrary position, they must at the very least indicate or invoke a particular piece of legislation. In the supplementary heads of argument filed on behalf of the African National Congress, reference is also made to the European Commission's guidelines on political party regulation, and particularly principles 3 and 5 of those guidelines. My lords, my lady, in the interest of time, perhaps I need not read those particular principles. But the point is to be made is that the approach adopted under our constitutional regime most certainly accords with the international experience of not imposing unnecessary limits to these fundamental rights. Further, so thus far from providing a legal basis for limited and enshrined rights, the DA is unable to point to any legal basis, and that must be a death knell to the application. The second point, or the second topic that I deal with, which is political involvement in staffing decisions, goes to the second proposition. And that is what Mr. Katz contends, that in an ideal society, the process of appointing persons to the public administration would be wholly apolitical. And this most certainly is a theme that is advanced in the founding affidavit. The point to be made, and we've made reference in the supplementary heads, for example, to an empirical study conducted by the Organizations for Economic Development, an OECD working paper drawn up by Matheson, which we've quoted liberally in our supplementary heads of argument, is that there is really no such thing as a single interpretation of the phraseology political neutrality within the public administration. Matheson, in fact, goes on to point out, and you'd find the reference to his work that is within the joint bundle as section 07, commencing at pages 174 to 248, that political involvement is warranted where existing structural arrangement render it necessary that the executive takes a firm hand in ensuring its policies derived from the manifesto of the political party are implemented. Within the context of South Africa's unique history, it of course cannot be gainsaid that it would have been unreasonable for the African National Congress to adopt a policy which has the object of ensuring that the movement's goals are not hampered by reactionary forces. This is, of course, one of the objectives stated within the cadre deployment policy itself, because it cannot be gainsaid that at the dawn of democracy, the ANC took over a public administration which, if not openly hostile to its policies, was at the very least skeptical. Indeed, the ANC and a mass of black South Africans had to agree to a sunset clause to guarantee white civil servants, being the very bureaucrats which had propped up the apartheid regime, a stake in the new South Africa. Now, I make these particular points because public service is inherently, and this is again with reference to the works of Matheson, is inherently a political creation and can never be fully apolitical. Matheson, for example, cites as an example that the Thatcher administration in the UK was held back by an unresponsive civil service, which was an obstacle to the implementation of her policy changes. He concludes that ministers in a legally appointed government have the legitimate right to control their government's organization and reduce deflection from their policy direction. Now, of course, the starting point as to what values inform. Now, the starting points as to what values inform our public administration are to be found at Section 195, Chapter 10 of the Constitution. Now, I seek to briefly go to that particular section. It sets out a series of values which the public administration must seek to achieve. For example, a high standard of professional ethics must be promoted, efficient economic and effective use. It must be development-oriented. Importantly, at subparagraph F, that's Section 195, paragraph 1, subparagraph F, it says public administration must be accountable. What you will not find, my lords and my lady, is a single statement at Section 195 of the Constitution which requires public administration to be apolitical. And this is an important point, because much of what has been advanced in these particular proceedings is the ideology of the Democratic Alliance, which has been dressed up as law. Section 195 does not require an apolitical public service. It requires an efficient public service. Those are part of the values. And importantly, in modeling the ideal type of public service to be achieved in South Africa, Section 195 sub 3 and sub 4 leaves that task to Parliament. Section 195 sub 3 reads, national legislation must ensure the promotion of the values and principles listed in subsection 1. Section 195 sub 4 reads, the appointment in public administration of a number of persons on policy considerations is not precluded, but national legislation must regulate these appointments in the public service. And as we know, various pieces of national legislation have indeed been adopted, one of which being the Public Service Act itself. And what is the sort of model that is presently in place in South Africa? As Matheson contends it, we currently have in place a sort of hybrid model, where there's recognition that most certainly when it comes to level 1 appointments, such as director generals, the executive is allowed more of a discretion within such appointments, but appointments lower down in the ranks, be it at level 2, DDG, senior administrators, and the like, adopt a hybrid process where it is not only the discretion of the relevant executive minister that is taken into account. There's an entire process of shortlisting, interviewing, and vetting of those candidates, and there are also minimum qualifications that such persons have to bear. Now, the current scheme we have within the country does not simply conceive of achieving the values in Section 195 as being a process only strictly tied to the appointment of persons into the public administration. It draws various lines. So, for example, there are different sets of considerations when it comes to dismissing a director general within the public service or dismissing a normal civil servant within the public service. Similarly, when it comes to issues such as promotions, transfers, the lines are drawn in different areas because these are complex values, and these values will simply not be achieved by simply saying what is required is an apolitical process, and all the values in Section 195 would then be realized by simply having an apolitical process. In fact, as Matheson shows with reference to the Thatcher administration in the United Kingdom, is that preventing political involvement within staffing decisions in totality is in itself undesirable because, one, it will not guarantee efficient outcomes, and two, it is likely to lead to a non-responsive bureaucracy. I now turn to still under this topic to what might be a more cynical aspect of this particular application. The court would undoubtedly have seen that there's currently a private member's bill before Parliament seeking to advocate for some form of reform to the Public Service Act. It has been proposed by a member of Parliament of the Democratic Alliance, and it is supported by the DA. I make reference to it as a cynical aspect of the application, in the sense that when the court has reference to that which the bill proposes, that private member's bill, and the court to find it at section 002-584. The court would appreciate that what the bill intends to achieve, the nature of amendment the bill intends to achieve, is extremely limited in scope. So effectively, what, under the heading of what they call limitation of political activity, the bill that the Democratic Alliance has proposed in Parliament only says this. It says political officers cannot be employees within the civil administration. It then provides a definition of what it then proposes a definition of what political officers would be. And they are essentially what the court will know ordinarily as the top five, being the chairperson, deputy chairperson, treasurer, secretary general, and the like, either in the national, provincial, or local sphere. And that is the sole amendment which it titles Limitation of Political Rights. It says you cannot hold political office and at the same time be an employee within the public administration. It proposes that should that bill be enacted into law, all such persons who fall within this particular category would have 1 year to give up their political post. Of course, that ambit is quite narrow, and is markedly different from what the DA proposes in this application. In this application, it tells the court that restrict in a fundamental manner the African National Congress right under Section 16 to freely impart ideas. Restrict in a fundamental manner the rights of members of the African National Congress guaranteed under Section 19 to decide themselves as to what the policies of the organization must be. It contends before this forum that it's appropriate for courts to be called upon to vet the policies of political organizations. But it dare not suggest or adopt such a preposterous stance in introducing a bill before Parliament. So the real question becomes, why does it seek such wide-ranging relief before this forum and not before Parliament as a deliberative forum? My lords, my lady, the last aspect of the matter that I wish to deal with pertains to separation of powers. Now, of course, and sorry, perhaps let me just take pause. The Ramakatsa decision, the full citation of the decision that I made reference to earlier, the Jutta citation is 2013, volume 2, BC LR 202, and is, of course, a decision of the Constitutional Court. The last aspect of the matter that the last topic I would like to engage is that of a separation of powers. Of course, much has been written about the separation of powers, and I need not per se make reference to any judgments. Judgments like such of the reactionary unit versus SIRA is cited and is included in the bundle of authorities already provided. The separation of powers principle has been noted as a principle that is implicit within our Constitution, and that was, of course, held as far back as the first certification judgment. And in layman's language, it deals really with the functions as constitutionally ascribed to the three different arms of government, and in which instances it may be constitutionally appropriate for the judiciary to interfere within the functional area of a specific arm of government. I've already referred this court to the fact that Section 195 sub 3 and sub 4 conceives of national legislation, in other words, Parliament, as the institution which must adopt laws to give effect to the values in Section 195 of the Constitution. And it's quite important to make this particular distinction because the deliberative nature of the law-making process which Parliament engages in is quite distinct and different from the lawmaking process which the courts, of course, engage in applications for judicial review. Now, Professor Hoekstra, reference has been made to it in the heads of argument, and the relevant chapters of that is to be found in the Bundle of Authorities. She has long proposed that the discourse of deference is bound up with the separation of powers in the areas of competence associated with the three branches of government. My Lord and my Lady, if I could refer you to a judgment not in the Bundle of Authorities, because I find this judgment as the easiest means of understanding the separation of powers doctrine and how it's to be applied. And that is the Minister of Environmental Affairs and Tourism versus Pambili Fisheries, 2003, Volume 6, SA, page 407, and it's a judgment of the SCA at paragraph 52. In the judgment, Justice Schutz explains deference which this court owes other branches of government as effectively engaging two different aspects. The first aspect is constitutional appropriateness, effectively which arm of government may most appropriately discharge a particular function, and the second aspect would be institutional competence, whether or not this court is better placed than the other arms of government to take the nature of take the nature of decision that is being called upon to take. We contend that when it comes to the issue of constitutional appropriateness, the text of the Constitution, Section 195 sub 3, Section 195 sub 4, cannot be clearer. It is national legislation which must be enacted to achieve the values of Section 195. And that would mean that Parliament, the two houses of Parliament, are the most appropriate branch of government. When it comes to the issue as to institutional competence, we contend that there is a wider variety of considerations when one approaches or one takes a step to public administration reform beyond that which have been engaged with in these papers, which is really just an attack on the ANC's cadre deployment policy. And an reference from the DA, Mr. Katz, accepts that whatever finding of this court on that score impacts not only upon the ANC, but impacts upon all political parties or all formations who have similar policies. So what this court is actually being invited to is to effectively create law which is going to have quite some breadth in its application. We contend that the considerations which should deter this court from engaging in that particular task is firstly that this court includes considerations such as, for example, is there truly a problem that needs to be solved? And these will engage considerations as follows. Does the current public administration adequately function as a constraint on political institutions at ensuring adherence to constitutional requirements, regardless of the implications for government? We say such an inquiry requires quite some deep level of deliberation. And that consideration would be, is a public service presently responsive to changes of political priorities? Does it sufficiently deliver on service delivery? Is a public service sufficiently inclusive, or is there evidence that its powers and resources it administers are being weaponized for party political ends. Another more important issue is, even if the court were to find that the present public administration, the manner that it is structured, does not achieve any of these ends, the further consideration is this consequent on the political administrative interface? To say, if we find, for example, that the public service presently does not sufficiently deliver on service delivery, is that implicitly tied in with the fact that there is an issue between the political and administrative interface, that the reason why service delivery is not being conducted more efficiently is due to unlawful interference by political parties or members of the executives or the like? The simple point we make is that this falls within the area of so-called polycentricity, in which Parliament and not the courts, merely because the methodology that they employ is more deliberative, where they engage with various stakeholders, is better equipped to attend to. And in any event, and this being my concluding remarks, we point out that the remedy pursued by the DA, being the fact that all political parties, as Mr. Katz concerns, should not be entitled to recommend candidates for public office, in itself has not been proven as a true remedy. It's an untested cure. Nothing before this court presently establishes that if the cadre deployment policy is done away with, if it's declared unconstitutional, suddenly our parastatals will start functioning properly. And that really is one of the chief considerations this court must bear in mind. But what we do know is we can well imagine the possible ramifications of a court acceding to the granting of relief in the nature that the DA seeks. It might well open the floodgates of lawfare, because what would prevent the ANC, for example, from dragging the policy of another political party, for example, that of the DA, which is in some ways anti-transformation, before court and calling upon this court to vet as to the legitimacy of the DA's policy in light of our constitutional regime. So one of the potential ramifications is that it will open up a new pathway for lawfare. The second consideration is that it might render political organizations less attractive to groups seeking constitutional and or social reform. My learned friend, Mr. Morrison, spoke about the fact that inbuilt within the Constitution itself is a mechanism to amend that which was unconstitutional to now become constitutional. Now, if this court were to close the space for groups or other political parties to advance matters which presently are unconstitutional, it takes very little imagination to see that this would directly lead to the breeding of subversive groups, because the political space has been closed to such persons. It will most certainly decrease the vibrancy of our multi-party system of democracy by dampening the debate on political matters. Why must Parliament, why must delegates at the ANC's National Conference debate on policies as to how to take our society forward if ultimately all that is required, as the DA would suggest, is that policies must be adopted in draft form and brought to this court for ratification? We contend acceding to the nature of relief sought by the DA would dampen our multi-party democracy. There will be separation of power harm. You've already been advised of the fact that there's a private member's bill already in Parliament. Parliament is dealing with the issue. Similarly, the executive is dealing with the issue. If one has a reference to Section 3 of the Public Service Act, it is the minister who is empowered to adopt norms and standards for reform. There is no need for this court, and it most certainly would be premature for this court to engage in that process at this particular stage. And lastly, but of course an equally important consideration, is that it would open the courts up to critiques as being a quasi-political body.
You have mentioned that, right?
Yes, indeed.
My
Lord, my lady, those are my submissions. Those are the submissions for the African National Congress, and would move for the application to be struck with an order of cost, including the cost of fire counsel, as the court pleases.
Thank you very much. Mr. Morrison?
I'm nothing further to add. Thank you.
Thank you very much. Let me just check with council. We agree that we start at 9:30 last time. Is it still the suitable time for everybody? Maybe Mr. Maleka, because he'll be present. Thank you very much for the submissions made. We will adjourn until tomorrow 9:30. Court adjourns.
Thank you. 25 minutes. Fantastic.
Yeah, that's up through.
It's a bit of a surprise. It's the costs.
It's a water tank. It's a water tank. Really? That wasn't very nice.
Of course, not the case, but there's ANC's coming in.
Oh, that thing's good.
We had
Because if you then have to have this fight over what is the additional cost.
That's why I didn't.
The section 74 point. Because he's coming. Yeah.
Well, I was wrong about mine.